all batch materials are pending here.
Please stop.
Because why am I always?
I understand. The relied upon judgment traveled to Supreme Court and it is affirmed.
Yes.
And all these review petitions are on the basis of that relied upon judgment.
Yes, my lord.
Give it.
You give it also because it is retired from 2008 and they have not received pension, my lord.
I'll list it this week. How many review petitions are there?
Only one. I mentioned.
No, you give the number related.
Then this is my case, my lord. Unless until they. No, how can I see?
If you can give all the matters, I can list it.
I have review petition order already dismiss.
Can you give me?
Other say order to produce at the time of hearing.
Yes. No, please give it to.
Now, how the number they have not informed to me.
I understand. You please give that order at least to him. He will try to locate all the related matters and get it listed. Okay. So that all the matter could be disposed of. I understand, sir. You give you. I understand. I will list your matter along with the other matter also. So I understand it. You please, whatever you know, give it. We will try to locate.
Okay? This week, my lord.
Give the memos, please.
My lord, fresh CRLMC, my lord, similar matters are coming up on 14th, my lords, especially fixed that economic offences wing matter, Bhubaneswar, my lords. It's another fresh CRLMC, similar to it.
On 14th, you mention it?
My lord, let it be listed because it's numbered already. Okay. Let it come along.
Huh? Tag
if it's removed, numbered already.
Tag with
tag, my lords. Obliged.
GRK is 2002, my lord.
Give memos.
Target.
Give memos, all the memos. Give all the memos, we'll see. Yes.
Criminal miscase, once
give the memos, madam. 1 minute.
Mention item 1 to 8.
Item 1.
Yes. What do you want, madam? Okay, you want an adjournment on the request of for petitioner.
Yes.
On the request of the counsel for the petitioner, please see my counsel. Yes.
Item 9, 20.
Yes.
21 to 34. 35 to 42. 43 to 48.
44, my lord. Finally taken on HP.
Okay, on the request of you have not cured the defects. This matter is pending from 2023. You have not cured the defect. Are you serious about this matter?
Yes, sir. 1 week time may be given. In between,
You have not filed the condonation of delay application also.
my lord, filed.
Have you filed? Okay. Counsel for the petitioner undertakes to cure the defect pointed out by the registry within 1 week. Positively, release the matter after 1 week. In the event the defects are not cured, the notice will automatically dismissed without reference to the court. If the defects are cured, release the matter. Yes.
49 to 54. 55 to 60.
Malad, item 58, Malad.
Yes.
I am for the opposite party. On last occasion, I had requested for time to file counter. It's not ready, Malad.
Acha. Then counsel for the opposite party submits that in the last date of hearing, he sought the time for filing counter. However, the time is not ready. He seeks one more opportunity to do so. Lease the matter. Yes.
Malad, there is an interim order.
Interim order to control. Yes.
61.
Item 56. Kindly taken up on next.
On the request of yes, 20 56.
Item 56.
On the request of counsel for the petitioner, lease the matter. Yes. Yes. Which one? Let it be.
61 to 64. 65, 66.
Let's say item 65. Kindly taken up to. I have
Yeah.
objection, but because here
told me that he will take time today. It may be taken up next week, my lord, on
Will the
20th.
counsel for the petitioner seeks an adjournment? On
20th, madam.
Please the matter.
It is 138 enact the stay.
Stay is there.
आरो सप्ताह
You can't take stay in the 138 matter and sit over it.
20th को आसु से कौन तांगर उड़े bereavement एक तो family ले जाके
Okay,
नंदा
very
मुझे
good.
नंदा
Okay. Short date. Short.
Influence is good.
That's the problem. In 138 matter, there should be any stay. Yes.
67 to 74. 75 to 80.
75 may kindly be taken up, both the parties have come.
Okay. I'll take it up at 12 o'clock.
Well,
Yes. What are the offences?
married 376, married lady having 2 child. The lordship has directed the status report. I obtained the entire order sheet. No,
Pokso is
investigation is still open.
Pokso?
Yeah.
Pokso is not there.
Pokso, the married having 2 children. Madam. There is a
Okay.
family dispute.
Yes.
81 to 85.
My lords, item number 83. I'm on BCA lordships. Item number 83, I have informed the counsel for the other side. It's a employees compensation matter for final disposal. May I pray any other day?
Okay. And then Mrs. Naidu request for an adjournment. Yes.
There's an interim order not to release the money, your lordships. I've deposited in the court below.
Interim order to continue. Yes.
Obliged, your lordships.
86 to 91. 92 to 97. 98 to 102. Item 2.
Your lordships. Well, this is a matrimonial dispute, my lord. I have challenged the charge sheet is filed under 498 and 34.
Yes.
In-laws are there. Not
Issue notice to
after the 10 years.
issue notice to opposite party written ground forms. Yes. Next.
Item 3.
No coercive action, my lord. I is there.
No, what is 498? What course of action? Who is going to arrest you? Yes. Who want to? Yes.
Item 3.
My lord, on behalf of Mr. Yusidora, I am seeking for an adjournment.
The,
Item 3.
on behalf of Mr. Yusidora, there is a request for adjournment. Please the matter. Yes.
Item 4.
May I plead your lordship? My lord, I am in BC, my lord.
Yes.
My lord, the similar cause of action, another CRLMC has been filed by CRLMC number 175 of 2025, my lord. 2 affairs,
Same party.
same party, 2 affair has been lost. My lord,
Okay.
both the matter may be tagged if lordship desire.
Give the number.
175 of 2025, my lord.
Submit that between the similar matter being so and so, date or china
No, my lord, it has not been fixed.
is required to be heard to anonymously. Please the matter. Yes.
Date
Item
may be fixed, my lord. Deep lord.
Yes.
Item 5.
79
Cognizance order. Bail might have been dismissed or something. Pass over. Yes, pass. Yes.
Item 6.
6, my lord, on behalf of Mr. Yes Das, kindly pass on.
Pass over.
Item 7.
Seven. Vidamitra Food. What are the offences?
Census matters for 94, 354, 394. Just and charging or section 341, 294, 394, 526, 364 A of the IP.
What is his name? Her name is Sanjeev Rai.
Sanjeev Kumar Roy.
Any allegation against him?
Ira. But there is allegation matter 161 statement of the wife of the complainant is there. They have taken in the village. Thereafter they have asked some money and taken with 5,000 Which is from the charge sheet is for a very level process to manage case 25. Towards the end and 25.
Then we will dismiss it. Pass it over once pass over. Huh? Remind me after that. There's nothing in this. Yes.
8, item 8.
Well, it's item 8, I appear for the petitioner, which is a cab company based out of Calcutta. Well, I had a subsisting agreement, which is a commercial agreement with opposite party number 2. I'm a cab service provider. He's a local cab agency here. During COVID, there was some payment problem. I could not pay certain amount of money, and there is a 1cc case which was registered, and pursuant thereto an FIR has been registered. In the meanwhile, we have settled the dispute. The settlement agreement is here.
Okay. The dispute is arising out of a business transaction. Huh? I'll issue notice. Business transaction, and counsel for the petitioner submits that during the COVID there was a problem in the payment to the opposite party number 2. The FIR was registered. However, the parties have already settled the dispute. They have signed a settlement agreement dated 8 November 2024 or 2024. On the basis of the settlement terms, he seeks indulgence of this court for quashing up to the entire criminal prosecution. Issue notice to opposite party number 2.
Notice has been, already notice has been issued.
Where are they?
The first order your lordships will find in that
Where are they?
order,
Service?
9th of October 24.
Yes, yes. Notice was issued, but nobody had entered appearance so far. So far. Therefore,
I am for the petition.
The IIC, which IIC for decision? Is directed to serve opposite party number 2.
Infocity.
Opposite party number 2 and place a report regarding the same. Lease the matter and so on, so entry mode to continue.
Great. The
If
amount
he doesn't come, then I'll pass.
the amount pending was 23 odd lakhs.
I'll rely upon this and place it on record.
Oh, great. Great.
Yes.
Item 9.
Well, the complainant was tendered evidence as suitable one and also procedure. Thereafter, the record.
You are the complainant.
Well,
yes.
And the record was posted for further evidence. At this stage, the complainant filed an application under section 311 to exhibit certain documents, and the documents that have been deliberated in annexure 2 ballot petition. And these documents they sought to be exhibited in that documents are neither relied upon nor discussed in the body of the complaint petition. So during the pendency of this case, they cannot rebuild the complaint petition. And
What are the allegations against you?
Well,
What are the
allegation that during the financial year 2013,
you have not deposited the tax?
I have deposited, madam. Along with the fine, the entire amount has been deposited.
Yes.
So they are not entitled for anything right now. So my
Then there is now a procedure of a compounding.
compounding is there, madam. Compounding there, they are again charging madam the 2% interest.
Whatever you want to compound, I'll issue notice. Let us see. Issue notice.
Well, the case is posted about 17th ballot for
no problem.
Well, the case may be.
You are the builder. You have been doing like this.
Well, stay. Well, order dated 6/3/2002.
I know you are hiding behind the technicality, and this builder is involved in many cases.
No,
many cases.
You are not hiding matters.
I know. See, this is City Con Engineers.
Yes,
I know. Many cases comes to my court. I know. Yes. I'll issue notice. Let us see. Sorted.
Well, I have also sought the copy also. No notice is required.
Yes. You must have the copy.
Well, I can tell my last occasion notice was issued and the endorsement is the item delivered my
Notice everything. Yes.
But the opposite battery no.
There is not completely required. Because
Service is complete, no?
He's alleged that 390 for the 395 cognizance has been taken. 4 persons police charge submitted charge.
No, division one.
Yes.
Then my lord, the informant and other statements there, it indicates in the cognizance order man, it indicates a description that indicates that the eyewitness has stated 6 persons is fled away from the spot. So CD is required.
CD. Call. Okay.
Hello, entry order.
Entry order. Yes.
Item 11.
My lordship, kindly pass over. Kindly pass over.
12.
Well,
13.
May I please, Your Lordship?
yes,
Your Lordship. In the present case, the petitioner challenges the rejection of his application under section 457 CRPC by second additional session judge Rahul Kela on 8/10/2024. Lordship. In the present case, the petitioner is the owner and the possessor of the alleged stolen property. The property was stolen from the possession of the employee of the present petitioner, Lordship. But the learned subordinate court rejected the same, thereby stating he has not submitted any document to prove his position over the
yes.
stolen.
Yes.
Lordship, however, there is no cross claimant in the present case, and so far the 457 CRPC is concerned, Lordship, it clearly states whenever the seizure of the property by any police officer is reported to a magistrate under the provisions of this code, and such property is not produced by a criminal court during an inquiry or trial, the magistrate may make such order as he thinks fit.
No proof of ownership. No sufficient documents.
Yes, no proof of ownership, what to do?
Lordship, however, in the present case, he was in the conscious position. The property was stolen from the conscious position of the
But
employee.
unless you show the ownership, somebody else may come and claim.
Lordship, there is no such cross claimant in the present case. Moreover, the IO has seized the property from the present accused person.
You might have got it from someone else. You might have theft it. Who knows? The owner will move an application under 457 saying that I am not an accused. My property released to me. Then what will happen?
Your Lordship, we have also submitted series of invoice and bills, Your Lordship, with regard to the.
You show me any document where your ownership could be, at least inferred. Unless ownership is established, how can it be released? That's the problem.
We have also annexed the job work challenge, Your Lordship, wherein it is stated there is a.
There are jewelries.
Yes, sir.
Jewelry item. Madam, you have to establish.
You mentioned that in the sale invoices, there is no proper description of gold ornaments. That is doubtful.
Will you file any document?
Yes, Your Lordship. Some time I can't afford. We will file some documents.
Or otherwise, what I'll do is I will give you opportunity to file a fresh application before 457 with all documents.
Yes, Your Lordship. Liberty may kindly be granted.
For the application of the petitioner under 457 CRPC has been rejected by the court below. First, the court, which order? First order?
Lordship 25 2020
by the court of SDJM composed Rahul Kela by its order dated 2/5/2024. The petitioner has taken up the matter to the revisional court by filing criminal revision number 9 of 2024 before the second additional cases says Rahul Kela. The revisional court by its detailed judgment dated 8/10/2024 passed the 24 rejected the prayer of the petitioner under section 457 CRPC for release of the jewelry item. While rejecting the prayer, the revisional court inter alia has taken a gender observer gender para 6 case para 6 case. The counsel for the petitioner submits that the petitioner has enough material to show the ownership of the jewelry item. Ownership over the jewelry item sought to be released under section 457 CRB. She seeks liberty to move press application before the trial court along with all the documents, along with all the necessary documents to establish the ownership of the material, ownership of the articles sought to be released in his favor. Liberty is granted to the petitioner to move fresh application. If such a fresh application is moved, the trial court is expected to deal with the contention raised by the petitioner, independent of the observation already made by the revisional court. With this observation, the petitioner move application with all documents. Okay?
Yes, Your
Yes.
Lordship.
May I please?
Yes.
Lordship, here I'm challenging quite a strange order of learned SDGM, wherein the prayer of the opposite party for passing of judgment directly without giving any opportunity to the petitioner who is an accused in the trial court has been passed. Now, my lords, just to give up. I'm appearing on behalf of the opposite party. So
Opposite party. On the
What is-
on the advance notice, so entered appearance for opposite party. Opposite party number 2. Opposite party number 2. Yes. Next, you tell me now. Yes.
Lordship. Just I'm giving a quick
Let us go to the impugn order.
impure order. Lordship.
Page number
It is at page number 19, Lordship.
19.
19, it starts at 19.
Yes.
Order dated 24th October 2024. This order arises out of
Petition filed by the complainant, praying for dispensing with the conducting of stress trial and purposing judgment establishing upon the prior agreement. Yes.
Lordship.
You
But I-
sought for press trial.
Lordship.
You sought for press trial.
No, the opposite party shot for a fresh trial. What has happened in this case? Quickly, I'm just within 1 minute I'm giving. In 2012, 1CC case was registered against me. In 2019, Lordship, I was convicted by the learned trial court. I preferred an appeal before the learned district judge and I succeeded in the appeal on the ground that the complaint filed by the complainant was premature. It's a technical ground. Thereafter, Lordship, challenging that acquittal order, the opposite party came before this honorable court in CRL LP. This honorable court, Lordship, kindly have a glance to page number 23.
23.
23.
Yes. Yes.
After hearing both the parties, passed this operative portion that is mentioned. Therefore, I am of the view that the complaint petition filed by the petitioner was not legally maintainable and the order of cognizance taken by the learned magistrate under
Where
130.
are you reading?
Lordship, page number 23,
Part of the order. Yes.
Lordship, that
Why?
italic portion.
Yes.
138 of NI Act as well as the impugned judgment and order of conviction passed by the learned trial court is not sustainable in the eyes of law.
Then fresh complaint was filed.
Lordship.
Yes.
In this, my lord, CRL LP, the operative portion is liberty was granted to the opposite party to file an application for condonation of delay under section 142(1)(b) of the NI Act, and the concerned court shall take into account the ratio decided in so and so. First, decide about the delay condonation aspect after giving opportunity of hearing to the opposite party and then proceed accordingly. Thereafter, my lord's application was moved, a fresh complaint was filed, application was moved on 142.
Delay was condoned.
Delay was condoned. Thereafter, I was aggrieved. I came before this honorable court and this honorable court passed this order, rejected my prayer. Then I joined the trial.
Yes.
In the delay condonation, my lord's order, at page number 34, kindly have a glance. Page number 34, para 14.
Yes.
As a sequel of above discussion, the prayer made by the complainant so and so is hereby allowed. Accordingly, the delay for filing the complaint petition is condoned. Resultantly, so and so.
Yes.
Now, put up on so and so for filing initial statement in shape of affidavit. On this date, the complainant filed, instead of filing a initial statement in shape of affidavit, filed an application for clubbing.
That the earlier thing you.
No, first he filed an application for clubbing both the cases. That was allowed. Even though I was aggrieved, I did not challenge that. Thereafter, another petition was moved, that is the impugn. As there is already, my lords, all the evidences are there, you directly pass the judgment. Now that is that?
What do you say? This is a fresh complaint. This has to be done fresh.
My lord, in that respect, once Supreme Court judgment is there, that it cannot be trial again de novo. It is reported in DCR 2015. Mensana Nagrik.
Give me the judge.
I'm getting.
What is de novo? You see, the court has given you liberty to file a press.
Because already trial has been concluded, and at no point of time trial has been challenged. Only because of a premature complaint that has been rejected by the set aside by the Honorable Appellate Court, and thereafter I come to leave petition, and leave petition was granted, and thereafter the accused person, the petitioner, approached this Honorable Court in CRLMC, which has been reflected in the cause list, which has been rejected by your lordship, referring all the Supreme Court judges and judgment and leave petition. That has been reflected in the cause list, my lord. CRLMC 4270. This is the judgment your lordship has rejected.
That is the next.
Yes. What are you thinking?
Your lordship has rejected that CRLMC earlier.
Yes. But see, the coordinate bench has said that you file a press complaint.
Press complaint was admitted. And
What is the check amount, by the way?
10 lakhs.
No.
The check amount was 10 lakhs. The conviction
check-
was 20.
Check amount 15 lakhs, conviction amount was
That conviction goes now.
Madam.
The conviction and everything goes.
Madam.
It is a fresh complaint.
Yes.
Okay, press complaint. So check amount is 10 lakh.
15 lakhs.
It will be tried.
15 lakhs. Madam.
Check amount is how much?
15 lakhs. Madam.
15 lakhs.
15 lakhs. Okay, 15 lakh.
Madam.
And it has to be tried FRS. That's what the indication of the coordinate bench.
Madam, this is judgment of Supreme Court. It cannot be trial again.
May
See, why don't you appreciate one thing? You were convicted, and the appellate court has executed.
I am the complainant.
I know. He was convicted,
Madam.
and the trial was concluded.
Madam.
And subsequently, on the intervention of this court says that you proceed afresh.
Proceed against afresh because it was a premature complaint. That still complaint fits.
I understand it. What is prejudice to you?
Lordship, I'm submitting the judgment which my learned senior is citing. Lordship, have a glance.
Hey, what is the prejudice to you? If
Well, it's-
he
at
says
least
that whatever evidence has come on record earlier,
Well, let's cross
only on the ground of delay, you got benefited.
Lordship.
The court says that okay, you file a condonation of delay and thereafter let it be proceeded. Now delay has been condoned, that part is gone.
Lordship.
And insofar as the main complaint is concerned, it was fully tried.
Lordship.
Earlier fully tried. All evidence has come.
Lordship.
Why to waste time again doing all these things?
Lordship,
Yes,
when
my lord.
it is a de novo trial, the law is very settled that becomes, my lords, non-est in the eyes of law. We have not, those evidences cannot be read here.
Honorable Supreme Court has said.
Honorable
that
Supreme Court, my lord, my
Unnecessary
humble submission
issues are
is,
fighting on technical.
my humble submission is this judgment which my learned senior is citing.
Amount is to be deposited. Since 130 matter, money should be deposited. There.
See, money when then 143 only 20%.
Can we find?
20% because the conviction goes. If the conviction goes, what had happened is he filed a complaint. Okay, that complaint was time barred. It suffered full trial. After that, the trial court convicted. He went to the appellate court. Appellate court says that the complaint itself was time barred, so therefore the conviction is converted to acquittal. Okay, acquittal. Again, it was the acquittal order was challenged here in the this court. This court says that in view of Jogendra Yadav, you move a fresh application for condonation of delay and proceed. He moves in a condonation of delay. Now delay is condoned. What he is saying is, or insofar as the merits of the case is concerned, evidence has already come on record. On that basis, decided. That's all. And he says that it's D no trial, you have to do it once. That's the whole gamut. That's the whole gamut.
This
only to linger the
Post gamut.
if that is allowed, Lordship, then I am a mute spectator. I will wait for my
Okay,
conviction.
I'll intervene, deposit 20%.
Lordship.
Decide. Let him deposit 20%. 20% subject to petitioner depositing 20% of the check amount to be disbursed to the opposite party number 2. At least the matter from so far.
today, before the London court below, today is fixed for argument.
You take first 20%. I'll decide the 20. See, on the garb of technicality 2012, the 138 matter is going on.
Lordship, I am
I mean,
operating in the trial now.
Then what is the prejudice to you?
Prejudice
You
is-
tell me. You tell me. What is prejudice? Whatever evidence is there,
Lordship.
if you are entitled to acquittal, you will be acquitted.
I am telling my
Why
lords.
to, why
I am
to
telling.
go for the
Is it possible, my lords, when a court?
My lord, this is the 138 act completely basing on
I
the
am
documents.
clarifying, my lords.
He's hiding behind the
Just-
technical.
That documents has already been examined.
Examine.
My humble submission is, if I will, what my learned senior is saying,
Come next
then
week.
there is 100%
Come next
conviction.
week. Come
Once
next week, I'll decide it
Lordship.
and come with 20%. Give it to 20% to him. 20% of check amount you first take. We'll see. Subject to 20% to be disbursed to deposit before the trial court. That will be disbursed to him. Then I'll decide this case.
Then,
Yes.
till then, my lord, stay may be granted because argument is fixed for argument today as my learned senior.
Judgment,
In view of,
judgment is
in
there.
view of the fact that the matter is submitted before this court, the counsel for the petitioner would seek an adjournment the next date of hearing. Please the matter 1 week for example.
Lordship, 2 weeks may be granted. for that.
No. 1 week. I'll decide it. 2012.
Because my lords, I have
138 matter.
instruction regarding 20%, it will be
Anyway.
a shock.
Actually,
That is why I'm-
What is shock?
Well, it's
143.
My lords,
Yes.
we can move, we can move.
No, I'm saying you have to give it.
Lordship, the
143
judgment-
capital A. You can't hide behind the technicality for
That is my lord. defense.
for 2
That is the only
decades.
defense I have.
No.
Lordship, the judgment which my learned senior is citing is totally not applicable to this case.
We'll see. Look. In 138, see, the statute says that within 6 months. What is this going on?
That statute
Trigger-
only gives
trigger.
me the defense, my lords, that it was premature.
You took the money, enjoyed for 2 decades, now you are hiding behind technical. And try and settle it.
Lordship.
Otherwise, if you suffer the conviction, you will be you have to suffer the compensation. Compensation will be used. Better that 15 lakhs you pay and finish up. That is, you will be better placed there.
Compensation amount was 20 lakhs, my lord.
That's what I'm saying. If you settle it, maybe within that check amount, matter can be settled. If you suffer a conviction, then it will go to a huge amount. That's a better idea. You settle it. Okay, you pay.
Obliged.
Item 15.
Lord, I have filed this application for quashing of the affair on the ground of compromise. My lord, here both informant and the petitioners are.
What are the offenses, sir?
Offense, my lord, 394. They are unknown to each other and FIR was registered against the named accused persons. And allegation, my lord.
compromise.
Again?
No document of compromise.
Investigation is going on.
Investigation subject.
Where is the charge sheet? Nothing. You except FIR, nothing. You have filed nothing.
Copy of the charge sheet. Certified copy of the charge sheet.
Why are you not placing? I do just don't understand.
Informant and my lord, that accused persons are present.
Have I invited them?
No, my lord.
Then have they done some grace to the court?
No, my lord.
Then
My lord, because matter.
you have filed except FIR. You have not filed anything, and you have not filed the affidavit also. Charge sheet has been filed. You have not filed that, and they have come means I have to pass the order.
No, my lord.
You have to see if
Yes,
it is
yes, ma'am.
settlement. At least you file the affidavit. You tell me the status of the case.
Okay. Yes.
At least the court is entitled,
Yes.
except a copy of FIR that is not readable.
Yes.
Except that nothing. And your Vakalatnama. Thank you for that. I filed the Vakalatnama at least. Vakalatnama is filed. Except that nothing. You please file all this thing. I'll put it next week. Okay. File everything and get the affidavit also.
Aye.
Place the affidavit on record and a detailed affidavit and charge sheet. Okay, next week.
But I am appearing in.
You file it.
No,
You file it. Okay. You file it, I'll put it next week. When do you want?
My lord, semane apune sedino ashibo.
Later. Yes. 18?
18. Yes.
Any problem on 18th, you tell me any.
No,
I can
madam.
accommodate you.
17 item.
18th will do. Yes. Come on.
Right.
16.
Shall I fix a time?
Yes, madam.
2 o'clock?
Yes.
18th, 2 o'clock. Huh?
Right.
Yes.
16.
At this stage of accused statement, my lord, the NBW has issued by the trial court, my lord.
Yes. In item 16?
My lord.
Yes.
Well, my prayer is that the NBW may be quashed and the petition may be permitted to appear in the court below.
Where is that order, sir? NBW order.
Annexure 2, my lord. Annexure 2, my lord.
What are you seeking in this?
I'm seeking for quashing of NBW, my lord.
Where is that order you have?
Order dated 19/4/2024, my lord.
9/4?
So 29/4/2024, my lord.
There's 16, man.
Yes, 16.
Okay, page 16. 19/4.
Okay.
29/4.
Okay.
24. Petitioner is agreed by the order dated 29/4/2024, passed by James Rahul Kala in ICC case number 604 of 2015, whereby NBW has been issued against the petitioner. The counsel for the petitioner submits that submission instruction that the client would be appearing before the court on or before 5th of March 2025, and resort to the remedy available to him under law. Subject to the petitioner appearing before the court on or before 5th of March 2024 and paying a cost of rupees 2,000 to the High Court of Orissa. The NBW issued by the court by the order dated so and so shall not be executed. Shall not be executed till 5th of March. This objection petition is disposed of. Yes.
Well, NBW quash the petition may be permitted to appear there, and
That's what I did.
okay.
But you have to pay 2,000 cost to the bar.
My lord.
What do you want?
Lordship has imposed and I'll pay.
No, you have to. You are a builder. You are a builder. Why can't you pay to the bar? You pay. You are a builder. Citycon engineering. You have to pay. You are going to pay to the bar only. Yes.
17.
I have done it. Yes, 17.
My lord, here, my lord, charge sheet not filed, and I have filed the quashing of the FIR. My lord, charge sheet not filed. I have filed the FIR, my lord, for quashing of the FIR and further proceeding. Here, my lord, 354 is the alleged offense.
That's right. 354. Then what do you want?
For quashing, my lord, and both the parties are present. Same. But my lord, in this case, charge sheet has not been filed.
Okay.
Have
Have you filed an affidavit?
Again, my lord.
The
My friend is
354.
again.
What are the allegations?
Again, my lord.
Allegations are serious or?
ନା ସିରିୟସ୍ କିଛି ନାହିଁ ମୁଁ ଆଜ୍ଞା ପଦାରେ ଠିଆ ହେଇକି ମଦ ପିଇକି ଘର କବାଟ ବାଡେଇଛି ସେ ଘର କବାଟ ଖୋଲି ନାହାନ୍ତି ନା ମୁଁ ଘର ଭିତରକୁ ପଶିନି
How much do you spend for drinks every month? 1 month money you have to pay to her, so that at least 1 month you will not drink. 1 month.
ଦି ଜଣ ପରସ୍ପର ଭିତରେ
At the expense of opposite party. Now, who is that lady in informant? Just ask her what exactly has happened. Please ask her. Marana.
Aye.
Miss Marana, just ask her. Nuisance of opposite party number 2, FIR number 2. Investigation case is still going on. At this stage, party from the recruit on the basis of the settlement terms. It counts the petitioner and opposite party number 2, the informant, are present in the court, being represented by the respective counsel and identified with them. They have also filed a copy of the Aadhaar card with the identity, which are taken in the part. The opposite party number 2, the petitioners in opposite party number 2 have filed a joint affidavit court dated 11/2/2005 and both are known to each other. First through para 1 para equal para 3 दिन, ठीक है. The opposite party number 2 is presenting the court and requiring the court submit that since we had see knows the petitioner due to misunderstanding the fire and the investigation of what is going on, and in the meantime she has settled the dispute and she doesn't want to proceed against the petitioner anymore. Regarding the settlement terms, and so purpose for the state is done, subject to the department of minor in water, so therefore there is no legal entity regarding the settlement terms, and in fact that the opposite party doesn't want to execute the petitioner anymore. The petition deserves money, even otherwise subject to the petitioner pay. It is a defined this time to be equitable exercise. Hence, in the case of the petition that governed by yes, yes,
Yes, ma'am.
no, that's right. But what exactly had happened? Accordingly, the cost will be.
She had given the setback and yes.
So 5,000 you pay. Subject to petitioner paying 5,000 rupees.
2,000.
Pay you are wasting money and on drinking. You pay to that lady 5,000 to the informant.
Right.
5,000.
Okay.
You tell her that she will.
Yes.
She will get 5,000. Okay. Tell her and file the receipt. Huh? Yes. Next. Aadhaar card you.
Should be.
Yes.
तारे लगी थी बोले आधार कार्ड.
आधार कार्ड लगी सु.
एफिडेविट लगी.
आइए.
गोटी लगी. अन्यथा भी
बहुत victim रो. Victim रो लगी. Victim.
Victim लगी थी ना.
हाँ.
You
दे दो चाहे.
petition. Yes.
Lord, the limited prayer of the petitioner, my lord.
Yes.
Here in this case, my lord, this case is NDPS, my lord. And implication of the petitioner is only basing upon the co-case statement. Apart from this case, another similar case has been instituted for the petitioner, my lord. And while granting to in another case, this case has
But what is your prayer? Just see.
my lord, the only prayer is Tufan Singh, my lord. My bail application may be considered in the statement judgment of the
See,
Tufan Singh.
if
CAB say court,
no, you tell me, if you are relying upon a particular judgment,
my lord.
do you need a direction from this court that the trial court should consider?
Because, my lord, antecedent part is there, my lord. And antecedent part is already discussed while granting in another case, my lord. It
You can't do all these things. I'll just record your statement.
my lord.
You argue.
Yes, yes, my lord.
Okay.
And Tufan Singh is mentioned.
In this petition, petitioner is seeking, petitioner is exploring the following relief, prayer relief from following. The relief sought by the petitioner in the present case is vague. Hence, no specific direction is required. However, Mr. Padil and counsel for the petitioner submits that he would move press application before the trial court for grant of bail, relying upon the judgment of the Honorable Supreme Court in Tufan Singh versus.
Yes, my lord.
So and also urge the ground of parity before the court below.
Ground of parity may be not applicable, my lord, but ground of parity may be not applicable. Yes.
The petition is granted. This court is not inclined to interfere in this matter. However, the petition is granted liberty to make press application. If such application is moved, same shall be considered in accordance with the law laid down by the Supreme Court in Tufan Singh. It will be considerable.
Yes.
Antecedent.
I will not say anything. Antecedent. Yes.
Obliged.
Yes.
19.
Order of cognizance has been challenged, where cognizance has been taken for the offences under 379 by 411, read with ballot section 51 I of OMC rule 2016.
Yes.
My lord, petitioner was entrusted with the work by the government under PMRI Yojana, my lord. And my lord, he was allowed under Annexure 5, my lord, we see Annexure 5, page 43.
Annexure 5.
5. By Executive Engineer RW Division, Baleshwar, wherein he has written a letter to the Tahsildar Hasgobindapur that forbid for procurement of boron for the road Sartha to Kasfal under PM GSY package number so and so, Valiapad under so and so, package number so and so, wherein he has written that with reference to subject cited above,
Temporary permit for 2000 cubic
my lord,
meters
to
of
carry this boron.
Yes.
And on the while I was carrying that boron in my Iowa, I was
From private land, Bhagirathi Singh.
ballot. Because borums are not available in Baripada, in Mayurbhanj district. Work was going on in Mayurbhanj. So I was allowed to take the borum from Baliapad. On the way, my vehicle was intercepted and case of 379 by 411 has been registered.
Must be excess of
Must be, might be.
How much? How much? Because see, this permit says that 2000 cubic.
Valid.
How much is it?
There, I have given the charge sheet. My acknowledgement may say from that.
Issue notice. Issue notice. Get in.
Yes.
If the beyond the permissible limit is there, then he is in.
Yes.
If within that permissible limit, he is out. Simple.
Yes.
Yes. Issue notice.
That charge sheet. Charge sheet I have given that. Yes, my acknowledgement may
You
get.
get inside. Yes.
20.
Same manner. Same
20.
petitioner, man. Yes.
He Dhananjay and he is also same.
Same two works ballot.
Murum.
Morum.
से ज्यादा दिया जाए किंतु काम हो जाए
I know. This is.
I am calling
Morum.
He might not have satisfied your person. This is a scam. Sand scam and all this are scam. In the name of they take a permission
yes
for a smaller quantity, they keep on doing.
yes
this stuff. This is the everybody knows it.
Yes.
Everybody knows it. But in how many cases you registered the case and for what reason you that also everybody knows. That's the whole difficulty. Anyway, we'll see. Yes.
The interim stay.
What is the stage?
Stage ballot.
What is the stage?
next week
Put it next week.
If such a situation requires ballot, I will file an application.
Next week I'm putting it and finish it up.
Ballot.
Yes.
Like charge sheet I've given ballot.
You
It's
come
not
with the
there.
preparation, I'll finish it. These are small matters,
Yes.
not to be
17 or 18 ballot.
18. Like 19.
19
19. Okay. And don't actually, if you ask for adjournment, then I'll have to give.
positively I'll take
Yes.
21.
Note down these matters where I'm not giving stay. At least in next date, you don't ask for adjournment. If you say that I have no instruction, I'll have to give the stay. Yes.
21 kindly pass over on.
Pass over.
22.
Your Lordship, here I have a challenge. The order passed by the Learned JMSC PPL in 1cc number 85 of 2016.
Yes.
Dated 24/8/2000. Yes, Your Lordship. 20/8/2024. It is a NI Act case. I am the accused. And the complainant has already been examined. And and he's closed. Evidence was closed. That's it for the accused statement of the.
So what do you want now?
I have filed a petition there to summoning branch manager Nimapada.
You are the accused. You are the accused. You are the accused.
Yes, Your Lordship. Because he is complainant witness. He is the complainant witness. Complainant has not examined singularly that.
Where is that order by rejecting your application?
My Lord, Annexure 1, my Lord.
1. Your application is rejected.
My Lord.
Yes.
By order page 14. Because I want, Your Lordship. He says that
what do you want to ask the branch manager?
Your Lordship, I have mentioned there because this check is of year 2008 check. accused has relation with me. He clandestinely taking away this check, which is a loan check, loan amount check, and producing this check, he has filed this. He said that on 1/3/2016, I borrowed money from his house, 80,95,000. Borrowed money without any money received, anything. Thereafter, a check was issued when he demanded an 31/3.
What do you want to ask the branch manager?
Yes, because that check is present status of the check, Your Lordship. Because the check was bounced, and holding that there is no sufficient amount.
Right.
But this check was of year 2008, and it is a loan issued on 2008. That check amount, that account has been closed already, and he has not intimated whether this account is closed, whether that money. Simply he said, and the complainant also not disclosed when he deposited the check.
No, let us come to the complaint.
Complaint petition is there, Your Lordship.
Yes, in the complaint he might have said when he deposited.
No. He has not stated. Complainant, opposite party.
Yes.
When did the check was deposited? Your Lordship. And yes, page 16. That said check, UCO Bank, Nimapada, page 16, Your Lordship. I am going. In favor of complaint, leave of this liability returned by this banker without collection.
Para 3.
Para 3, yes.
Yes.
And amount for the region funds insufficient. Only said the fund insufficient. And in the account of the accused to meet the check amount rupees 80,00,000. There was a said check issued by the accused in favor of complainant.
Just come to page 70. Come to page 70. The list of documents.
No.
Memo. Just see the memo.
Yes.
Of written for the.
Check
you got it.
Check
Memo of the written by the bank of the complainant and accused. Office copy of the legal notice. So postal receipt. Memo is there. Check is there.
Memo of return he says, but check I have filed that check. Nowhere is stated. Check return certified copy.
Where is the check here? Where is the check here?
Page.
Yes, 2016.
Page 20.
Yes, I am there. 2016.
Se pocketing amount of Nija Hatere. I have not written that. Se tar Benudolo sir likhi dei so Nija Negiri.
All these things you have to put to the complainant. Why bank officer? Bank.
My lord.
If you in every 138 case, if you call bank officer, they have issued the memo. Your check has been dishonored. And the complainant has to prove it. And you have to put it to the complainant. Where is the complainant statement?
I have filed a petition there, Your Lordship. That petition.
Show me the complainant evidence. Show me the complainant evidence.
Complaint evidence is there, Your Lordship.
Have you put it to the complainant?
Yes. I am asking.
Show me that.
Cross examination.
Yes. Where is that, sir? Where is that?
Page 27.
27. Okay.
I do not know. This is not.
Where have you
say out of 50,000
come to the point. Where have you put that?
It is not a case. Accused never handed over any check to me, and that para 13, 23, and that I have obtained the check from the house of the accused without his knowledge, mischievously, and that the present check was of year 2008, and that transaction more than 50,000 cannot be made through the said check.
How will you say that 2008? It is very clearly, it is not overwriting nothing. Very clearly, it is 2016. It is written 2016.
Pardon.
Well, see, the check which you have enclosed here indicates the date of 2016. There is no overwriting, nothing very clearly. How the bank officer will know that what had transaction?
He said,
second page you and
because he will come with a document with my say close.
That's a different story. You are asking a bank officer to come.
My lord.
And you want to ask what question you want to ask, whether it is issued on 2016 or 2018. 2008, 16 it is clearly issued. And there is a memo to that effect. What the bank officer will come and say?
My lord, another question is
And
that
in 138 case, you start summoning bank officer by the accused, then I don't think all the bank will be closed. Everybody will be running around.
in para 4 I have stated
can't-
my petition.
Hmm.
I have 5 petitions there. So for the interest of just the record of letting the passbook of accused loan CC account number up to date status.
Your entire case is the check was issued in 2008. And in 2016, it is manipulated and
manipulated by
This is
him.
the entire case. If that is your case, then the complainant will answer it, not the bank officer.
Complaint kalani na yeah. Complaint he has not produced that close kar di. Se close kala pore ame कहूची that amar cost re ame ani.
Where have you put that question to the? Yeah, you have closed the bank account in the year so and so.
Yes,
Something of that. Where is
my
that?
petition? In my petition para 2, that the complaint has mentioned the complaint petition the branch manager UCO Bank witness number 2 and branch manager witness number 3. Now the complaint closed is evidence, but he is not produced so-called witness number 2.
Come to page 28. Question number 24 and 25. 24 and 25. Read it.
My lord.
Read it. Read it 24 and 25. Cross it.
24.
24 and 25.
Page.
No, page 28.
Oh,
page 28, 24 and 25 is the questions put by you to the complainant. Thereafter, what remains? Why should the bank officer come? Read it. On your cross-examination. I have presented the check at UCO Bank on 2/4/2016.
My lord.
And again on 8/6/2016. And it is not a fact that the check was not dishonored by the bank for the insufficient fund. These are the questions put by you to the complainant. Thereafter, why bank officer will come?
But he has not stated in his petition file. So complaint petition is kichhi nahi.
I think
complaint petition is kichhi nahi. Ethi se कहउଛନ୍ତି ना.
I think you have to stop here.
My lord, cost I think
you don't have a case. What I am trying to help you out. Not that I'm finding out some way out to give you something. But what to do? You cut your hands like this.
ଗୋଟେ ଲୋକ 2200 ଟଙ୍କା ପେନସନ ପାଉଛି କଥା କହୁଛି 2600 ଟଙ୍କା ସେ ପେନସନ ପାଉଛି ମତେ ସେ ସେଇ ମାସରେ ଦେଇଦେଲା 8 ଲକ୍ଷ ଟଙ୍କା ଫେର ଦେଇଦେଲା 5 ଲକ୍ଷ ଟଙ୍କା ଏତେ ପଇସା ଫେର କ୍ୟାଶ
You are correct. I'm not saying you are not.
ସବୁ ଆଜ୍ଞା ଟୋଟାଲ ଷ୍ଟୋରି
You may be correct.
ଆଜ୍ଞା ଭଲ ରିଲେସନ ଏମିତି କାମ କରିକି ପଇସା ନେଇଯିବ ବସି ଆଉ କଣ
ଆପଣ ଶୁଣନ୍ତୁ ଆପଣ ଏଇ କଥାଟା ଆପଣ କମ୍ପ୍ଲେନ ପଚାରିବେ ନା ବ୍ୟାଙ୍କ ଅଫିସର ଆପଣ କେବେ ବ୍ୟାଙ୍କରେ
ବ୍ୟାଙ୍କ ଭେରିଫାଇ କରିବ ନା ମୋର ଆକାଉଣ୍ଟଟା କ୍ଲୋଜ ହେଲା ଷ୍ଟାଟସ ରିପୋର୍ଟଟା
memo that is job memo has been exhibited and towards that you have not asked a single question, rather in the contrary you are asking that it was deposited such and such day and dishonored. This is the question you have asked to the complainant. What to do? You should have a circumspective question you should have put. You are not guarded. And the Pochari, you have invited all these things. What can I do? And after this, you want a bank officer to come? I don't think you can. I'll just issue notice for your sentence. That's all. I can't help you.
Further proceedings?
No question. I intended to dismiss because you are frustrating so much. I am just teaching. Okay. But it is a case of dismissal. Okay.
No, notice ଆସୁଛି କହିବ ସେ ସବୁ
I'll just issue notice. Just simply issue notice.
ଆଉ further proceedings?
No question. I am dismissing it. I am just trying to help.
ମୁଁ ଆସି ଆପଣଙ୍କୁ କହିବି ଯଦି କରିଦେବେ ଆଉ କଣ ଯଦି ୱାରେଣ୍ଟ କରିଦେଇଥିବେ କଣ କରିଦେବେ
Simply issue notice. Yes.
By rest of procedural lordship.
Yes. At 2 o'clock you are going somewhere. Let us not break the rules if you permit. Otherwise I'll do it. No problem. If you have some work, I'll do it. Do you have any work? Okay. He has some problem. 21.
May I please? Pursuing of discharge petition, my lord, kindly have a glance. Page 13 to the affair.
13?
13, 1-3, my lord.
Yes. Who are you? You are.
I am the petitioner. It is alleged that I am the owner of the cement work. And the cement godown has been closed since 30 years. It is alleged as per affair, since I could not give him proper money for treatment, the case was registered. I am reading, my lord, towards middle, my lord.
Yes.
ଏହି କାମର ଭଗବତପୁର ଗ୍ରାମର ମିର୍ଜାତୁଡୁ ନେଇ ମିଟୁ ମଧ୍ୟ ଥିଲେ କାମ କରୁଥିବା ସମୟରେ ପାଚେରୀଟି ହଠାତ୍ ମୋର ସ୍ୱାମୀ ଓ ମିର୍ଜାତୁଡୁ ଉପରେ ଖସି ପଡ଼ିବାରୁ ମୋର ସ୍ୱାମୀଙ୍କ ଡାହାଣ ଗୋଡ଼
Where is the charge sheet? Let us see.
Charge sheet.
Where is the statement?
Charge sheet case 21, my lord.
Where is the statement of the
Statement, my lord.
161 statement?
Last reason, directly to file the 161 statement.
I know, that is the reason I am asking.
But in the charge sheet, nothing has been mentioned. In the charge sheet, just mentioned as the investigator case has
See, last time you argued at length, what I remember. And I said that you have not filed adequate documents. And you took time to file the document. Now you have not filed the document. That's the long and short of the matter. And even today you have not filed.
And then just
No, it's, all are paperless. If you give this paper, if I rely upon, where will I keep that? It has to come on record. That's the reason I passed that order. And that order was passed in January 30th. Yes, right on. Pursuant to the order dated 30th January 2025. Additional document has not been filed. Mr. Ponda seeks one more opportunity to place on record the additional document. Let him do so within a week, least after a week.
Madam, pardon, I pray one thing. In course of the day, I am filing.
You should have filed. You are wasting
by mistake.
time.
I was-
File it. I'll
my
after
lord-
1 week. After
My lord, I pray, my lord. Friday. I can, in course of the day, just now.
See, you don't, you know, the entire system is getting chaos because of that.
Or Monday.
Let us follow a system, not that
Monday, because
I have recommended. No, no.
the
question.
court has.
Next set. Yes. I have given this small matter you are taking for unnecessary time. Yes.
23,
You file it immediately.
Just now filing. I pray Monday or Tuesday. I
No,
don't know.
listen, everything you have to file, not that one statement somewhere. After hearing, you will say that no, I need some more time. All the statement you file. Because you are seeking discharge, you have not filed anything. What to do? How will I appreciate it? File the entire document. Yes. Next.
24.
Yes, sir.
May I please, ma'am?
Yes.
My lord, the other day, I was arguing that the complaint petition is incomplete. It is without affidavit.
Yeah.
And my lordship has been pleased to direct me. Yes. My lord, if my lordship yes.
Commissioners Act will soon.
No. Oath Commissioner Act will come later. First is CRPC, my lord.
Yes.
297. Lordship may take it. CRPC 297.
297.
Yes. Authorities before whom affidavits may be sworn.
297. 290. 1 minute. Yes, sir. Yes.
Authorities before whom affidavits may be sworn.
Yes.
Affidavits to be used before any court under this code may be sworn or affirmed before any judge or judicial or executive magistrate or any commissioner of oath appointed by High Court or Court of Sessions or any notary appointed under the Notaries Act. This is very clear. And
not very clear. It's you are just see any judge.
Yes.
So it was before judge.
No.
That's what I'm saying.
No, it is not before the judge.
Just see. See, it was presented before the judge.
The complaint petition was presented.
Complaint petition only.
Yes, complaint petition was presented, but affidavit was not done.
Just read it once again.
The affidavit was not sworn in.
Just read it once again. 297. Authorities before whom affidavit may be shown.
Yes.
Okay. Affidavit to be used before any court under this code.
Yes.
This affidavit was used.
Yes.
Complaint along with the affidavit was used by any such person. as to the fact contained in this affidavit, sorry, may be shown or affirmed before first A, any judge or any judicial or
Magistrate.
executive magistrate.
Yes.
So if it is before judge,
Before the magistrate. Magistrate. But where is the affidavit? That place is blank. He has not shown in the affidavit.
See,
Yes.
that what is missing. Therefore, you are saying.
What is not his sign was not identified by the advocate. The court has not put his seal.
Advocate signature is not required. I'll tell you.
Not required.
Why? Because he has filed wakalatnama and went along with the wakalatnama complaint.
But the magistrate has to put his signature in the affidavit. Where is that signature?
And show me the proceeding.
That Lordship may kindly come to.
Has he said the complaint is placed before me?
No.
Where is that?
No. He has not stated. Lordship, it is simply a petition filed before the magistrate.
Please show me the proceeding. Let us, because we are discussing about a legal issue.
Yes.
So
And page 9, Lordship may kindly see. Annexure 1, page 9. It starts before the judicial magistrate first class. 1CC case number 405 of 2022.
Where is the proceeding? Presentation. Proceeding of this court. Judicial. I'll call for the proceeding, the entire proceeding. From the trial court, I'll call for proceeding.
This is the certificate copy.
Lordship may see. The proceeding is not there.
Put his signature. That is not there.
I understand. He is not necessary that he should put the signature. If it is reflecting in the proceeding, then the story is different. It is presented before me.
Order sheet to court nahi hai kya?
Seda achhi kya apna pass?
Say order sheet, Lordship may call for it.
That's what I'm saying.
Yes.
Call for it. Because this is an issue to be answered.
And also, as per the GRCO criminal, my lord, section 24 of the GRCO criminal, affidavit has got a specific.
Can I just see GRCO?
Yes, ma'am.
This is the
Section 24.
24?
24 of the GRCO criminal.
And what commission act you have? 24.
Say the mark, tar bam. Dodi flag lagi ta bam.
24. No?
Affidavit ro jo format tag achi, tatre ko aji kono, the deponent having been identified by.
Same thing. GRCO also says the same thing.
Yes.
297, same. Before any judge, magistrate, or commissioner appointed by the High Court. Or the
more koi katha hai jaha pakre bhi affidavit korantu, but he has to sworn that affidavit.
That word is not there. There you are correct. I am not on that.
Eti kon likha hai affidavit pata dekhondu.
Yes. There you are correct.
The deponent have been identified by.
Not recorded. I have seen it.
Yes.
It's not.
That is blank. So he has not sworn the affidavit before anybody.
So, but in the proceeding, if it is written, it is presented before me and I am accepting it as an affidavit, then the story. Generally, it happens.
No.
The complaint is.
No, the magistrate will not ignore this defect. Without an affidavit shown in either before the court commissioner or before the notary or before the executive magistrate, the court ordinarily and should not accept the petition.
Well, issue notice and call for a report. Issue notice.
It is incomplete petition.
Call for Mr. Mishra, legal counsel for the petitioner submits that the complaint is not maintainable in the eyes of law in view of Priyanka Srivastava so. Particularly because the affidavit attached with the complaint has not been shown or attested by the affirmed, shown, affirmed, and attested. Shown, affirmed, and attested by the either by the
judge or by the judicial magistrate,
by the learned judge concerned or by the court commission. Issue notice to opposite party number so and the trial court is directed to transmit the proceeding of the CC number.
On CC number 405 of
2022 or 21?
22.
More writing. 22. Sure.
22. 2022.
Okay. Let us see.
And I have filed for.
I have the petition.
Because my discharge petition has been rejected.
Petitions are moved in application for seeking amendments And if such application is moved, then some consider. Yes.
Pardon, my lord.
No, wait for some time. After 15 minutes. Yes. Yes, Mal.
Item 60, your lordship was pleased to direct for appearance of the informant. They have
Which one?
item 60, my lord.
I go further. I go in the ascending manner, not in a descending manner.
No, I'm not residential to take descending manner. I suppose to.
Wait, I'll take it. Yes, next.
24.
My lord, in this case, the petitioner is challenging the order under Annex 4 passed by the Lord Executive Magistrate Office of the Sub-Collector Khurda in a proceeding under Section 163 of BNSS Act, my lord. My lord, in the self-same issue for partition of the landed property, the judgment under Annex 1 passed by the judgment and a decree passed by the Lord.
But you come to the prayer. What have you asked? Permit the petitioner to construct his house over the suit land.
My lord,
In a 482 proceeding, I'll permit you to construct the house.
No, my lord. I am first prayer is, my lord, to quash the order dated there.
Why are you making this kind of prayer? Am I injunction court or suit court? What is this?
144 proceeding the notice is to opposite party to appear kare.
How will I ask for
Yes, sir.
give a direction to construct?
Yes, no, never, Lord. But without appearing before the executive magistrate, without filing the objection that there is the judgment decrees there, can directly come to the High Court.
Where is the notice?
In view of the order, my lord, on
Page 32, Lord.
my lord, status quo was issued, my lord.
Okay, wait. This is the notice, huh?
My lord.
Yes.
My lord, in the order, my lord, under Annex 4, my lord, the status quo was issued for construction.
File question. Appear kariye objection degi
Submit show. And it is only you have been directed to appear and give show cause and tell all these things. There is a tree and all, and it will be dropped. It has to be dropped.
My lord.
I'll record that.
My lord.
Okay. Where is that decree?
Annex 1, my lord.
Annex
1 is a judgment and a page.
Page 23, the judgment decree.
23.
23, 24, 25.
23. What is this decree about? 23.
Suit for
Suit for a partition, my lord.
Partition.
My lord.
Petitioner is aggrieved by the order dated 13/1/2025 passed by the executive magistrate cum sub-collector Khurda in miss case number 9. 9 of 2025, whereby whereby he has been, they have been summoned to appear before the magistrate and so cause to the motions initiated by the opposite party under section 163 BNSS. When counsel for the petition submits that the civil judge, senior division, while its judgment dated 28/2/2024 has already decreed the part of the decreed half of the property subject in his favor, while favor half not 50%, na? 50%, favor. Therefore, the initiation of the hearing by the opposite party under 163 BNSS is motivated. I am not inclined to entertain this petition at the stage of at this stage because the magistrate has only issued show cause notice to the petitioner. Petitioner is entitled to urge all these points urge this petition before the magistrate if by filing his reply. If such reply is filed along with the documents, the magistrate is expected to deal with the same in accordance with the law. With this observation, the petition is open. Yes. Next.
25.
25 minutes, my learned friend who is a fair counsel, lords. My lord, his case essentially hinges on paragraph, the ground number D, my lords, wherein he stated that because he was let off in a DP, my lords, and he should not face a criminal trial. This issue is sub judice, my lords.
Okay, departmental proceeding.
I have been exonerated from department.
I understand, because a batch of petition about
Yes,
8 petitions.
yes. My
I have
lordship was
His
placed
case
to my
was
lord.
covered only.
Okay, let's
After
wait
the-
for that.
My lord,
In
the
where we
arrangement may be made, my lord, for adjournment of the, because I have come up.
Yes, yes, same order, huh?
My
Same
lord,
order.
same.
The issue regarding the exoneration of the petitioner from criminal proceeding in view of
Ipso facto.
criminal proceeding in view of his exoneration. Issue regarding the dropping of the criminal proceeding in view of exoneration
From the
In a DP.
in the departmental proceeding is
Sub judice.
the subject matter already heard and judgment
In number of cases.
in a batch matter. Hence, awaiting the judgment of those batch matters, leaves the matter on such and such day. In the meantime, the interim order pass will continue. Continue. I just come. You can do it. Been filed on such the case. Okay. On the request of the IO, showing the petition as an absconder, on the request of IO, NBW has been issued by the order dated so and so. Okay.
There एक रो NBW lost.
then 1000. Yes.
28.
एनबीए ऑर्डर 28/11/2024 एलियर बेल 12/4/2022 में
What the date? Yes. 28 NBW केवल
28/11/2024 में
1000 500.
29.
NBW issued on 13/8/24, my lord. During investigation, she was on bail by police, my lord. 41A answered 2, my lord. 41A service has complied, my lord.
500. Yes.
30. Enumerated 3/1/25. There is a case arranging of 130 NIA kilometers.
Yes. 138 NBA. NBW issued on 3/1/2025. 500. Yes.
31.
NBW dated 29 July 2024.
Mm.
Bail dated 24 August 2015.
Okay, 500. Yes.
32.
32 NBW dated 30 August 2022. Bail dated 21 September 2015.
15.
15.
Okay, 1000.
33.
33.
Manor Belgium matter 16/12/2014 religion bail 16/11/2017 NBW
1000.
34.
Yes, sir. 34.
Well, case for review. Say second appeal dismissed for default. CM
Dismissed default.
Conducting counsel as an expert. Restoration also has been dismissed.
No. Where is that order? Dismissal order. Where is that order? Dismissal order.
Order of dismissal, man.
Yes.
Order of dismissal.
Yes. Where is that order?
That's almost.
In the review petition.
No.
Review petition is dismissed in default.
No.
Then
CMA appeal has been dismissed.
is it 24 item? Which item? 34? 34.
CMA appeal has been dismissed. Second appeal has been dismissed. PMAPL has been decided on merit.
Yes. The application is dismissed
Yes, ma'am.
on merits. You
No,
could not explain.
Due to lapses of, I am explaining the review. Details. Yes.
Detail, but see, this is appealable order. But where is the question of review?
Due to lapses.
Where is the question of review?
Details of facts has not been explained.
Then you appeal against that order.
Details has
Review,
not-
where is the question of review? Review doesn't lie in this kind of situation. And see, it was dismissed in default. You move an application for restoration. You could not give the sufficient reasons for that.
Reasons.
That is what is the recording. The order is
Yes,
recording.
yes.
Therefore, it is again dismissed.
Dismissed
Again
on merit.
dismissed.
Yes.
It is by order. Now you want that review. A review doesn't lie in that situation. If you are agreed by this order, you have to file an appeal against that. Appeal against that. You have to. A review doesn't lie. Madam. The second appeal was dismissed for non-prosecution on 9/9/2000. Second appeal number. What is that second appeal number?
209.
209 of
98.
or 1998 was dismissed on 9/9/2022 for non-prosecution.
1210.
The petitioner moved an application under section application for restoration of the same by filing CMA PL number 136 about 2024. The court, while dealing with the said application, has passed the following order on 14/8/2024. The order ka pura utar. Land Council for the petitioner has moved the review petition against the order dated 14/8/2024 passed by the coordinate bench in CMAPL number 136 of 2024 on the ground that he has now explained the cause for the associate advocate not having appeared before the court on 9/9/2022. The ground urged by the petitioner in the review petition doesn't come under the purview of order 47 of CPC. Hence, a review as such doesn't lie on the grounds sought to be urged in the present proceeding. Hence, the review petition is not entertainable. Accordingly, the same is dismissed, but dismissal review petition shall not preclude the petitioner from resorting to any other remedy available to him under law. This observation review petition is dismissed. Yes. Yes.
35.
Projected 2 weeks after, my lord. 2 weeks after.
Okay. 2 weeks. On the request of Land Council from the petitioner, adjourn.
36.
Please, your lordship. The bail application of petition number 3, my lord, has been disposed of by the coordinate bench, His Lordship Justice A.K. Mahapatra, my lord, on 5/9/2024, my lord. Your
Then
lordship
it has to go to that bench. It has to go to that.
Whereas the petition number 3
Whatever he says, let it go to that way. I don't.
My lord, I am appearing for opposite.
1 minute, let counsel for the petitioner submits that insofar as the bail application of the petition number 3 is concerned, the same has been dealt with by the coordinate bench presided over by Honorable Justice E.K. Mahapatra. Hence, he requests that the present matter may also be placed before the same bench. In view thereof, leaves the matter before the Honorable Court, subject to permission of the Honorable ACJ.
My lord, I am appearing for a petition number 2. This matter is assigned before my lord. I think Chief Justice order, my lord. Kindly take a glance, my lord.
Flag C. D for Delhi.
If my lord, that will go to there, we are coming to you, my lord.
Acha. What is that complaint? What complaint?
Complaint was filed by advocate, my lord. One of the petition number 3. Thereafter, my lord, Justice not inclined to take this matter, my lord. And that will put acting justice, my lord.
Yes. What do you say, Mr. Mahapatra?
My lord,
You have some complaint against the court.
Yes,
so therefore, the court declined to hear.
Your Lordship, kindly see order dated 5/9/2024, Your Lordship, may see.
5/9, okay.
5/9/2024.
Yes.
For petition number 2, the bail application will be disposed of by His Lordship Justice A.K. Mahapatra.
That's right, but Justice Mahapatra is recused to hear this matter because of something is written by you. What to do? Write down, list it, simply list the matter. You just see the, the flag D, na? Flag D. Just see flag D and thereafter address. List the matter after 2 weeks. Yes.
One chapter, my lord.
37.
37 seeking short adjournment, my lord.
Okay, on the request of the counsel for the petitioner.
Obliged.
38.
By your lordships.
What matter?
Yes.
Delay.
616 days delay.
606 only. And the review petition. Yes. Review petition, how much delay?
That is.
Review petition delay, how much? Review delay, how much? You tell me.
Yes or no?
Review petition delay. Review petition delay. Delay 309 days. And the FAO?
616.
FAO delay?
616. 616 दिन.
ठीक है. Okay.
39 also covered by that your lordship judgment. 968 days delay in the FAO.
This is 38 रे थिला आपनकर एटा 38 रे
39 says.
एक मिनट डेट्स डिले तो अलग थिबो एवो ने एक मिनट आइटम 38 एटा आइटम 39
297 delay in the review petition.
39 रे 297 days review.
The
FAO is 968 days.
968 days
in the FAO.
ठीक है. Yes. 40.
Pray for a restoration.
Restoration of what, sir?
हमारे dismiss for non-prosecution.
Okay. For the reasons stated in the application, the CRMC number 936 of 2021 is restored to its original file. Leave the matter for hearing. Yes.
Interim order.
Restore to original file, everything is restored.
Okay.
Yes.
41.
I cannot 41 on behalf of Mr. Arkerot, my lord. An application filing of condemnation of delay, my lord. And last time the Honorable Court direction to issue notice to the opposite party number 1, my lord.
Is service?
Requisite has been filed in delay.
Late file. You have filed lately. The requisites persons to the order dated 17/1/2025. The requisites have been filed belatedly by the petitioner. Except the requisites and issue notice. Yes.
42.
Obliged.
40 na?
Obliged, my lord.
I forgot to submit my lord. See, lower court would order court in the 6 months state extension deemed to have been vacated.
I can't do anything because I allowed your petition. That petition, when it will be listed, you tell all. I can't pass that in a restoration application. I can't do all this thing. I have restored to its original file. What will happen in that proceeding? It will happen. In this proceeding, I can't pass the order. This proceeding is allowed in your.
Aji proceed koruchandi.
Whatever. I can't do except allowing your petition.
I pray, right?
Yes, today. Yes.
Like today, tomorrow it will be CRLMC as well, or day after tomorrow.
We'll see. Yes, next.
42.
42.
Yes, ma'am.
Okay, 42. Yes.
For restoration.
Restoration of what?
Dismissed for non-prosecution.
Huh?
Dismissed for non-prosecution, ma'am.
42. 42.
Yes, ma'am.
42 है
41.
42. Yes. Yes. Dismiss in report.
Dismissed for
report. Is there anything on merits?
Yes, ma'am. Well, in this case arises out of NI Act, ma'am. I was the complainant before the London
For
court.
the reasons stated in the application, the CRLMC is restored to its original file. Please the matter for hearing. Yes, next.
43.
You will be restored to the original file. Yes.
43, my lord, on behalf of Somnath Rai, notice will go on question of limitation.
Sorry, madam, I didn't follow you.
In this case, he is for the appellant, my lord. Mr. who is conducted counsel for the insurance company, his mother expired.
Okay.
Since sir,
Okay.
he is
Conducting
taking
counsel for
in this case, my lord.
petitioner.
Yeah, I have appealed for the decimal 1, 2, 3. 1, 2, 3. Your lordship may allow 1 week time. Next week, the next it can be disposed of.
Let a counsel appearing for the petitioner. Means that there is a bereavement in the family.
Yes, well.
Conducting counsel, conducting so a PS for opposite party, and also seeks an adjournment for filing response.
Yes, no, appeal. That is appeal. No, that response is required.
So what do you want?
You had your lordship put up this matter. One
Yes.
day after it can be disposed of.
My lord,
Request, huh?
my lord, respondent 4 को notice हुआ.
Se कोई wonder
This service any.
now wonder
In the meantime, the unserved respondent may also be served and refusal to be filed by the counsel for the petition. Yes. Next.
your lordship that to solve appeal memo.
You're giving a date.
No, giving. I am not saying about the date. Appeal not to solve appeal memo to me.
May give a
दे आज दे.
45.
and counsel for the petitioner appellant also undertakes to serve memo, appeal memo on the counsel appeal for opposite part number 2 and 3.
1, 2, 3.
1 to 3. Okay. Yeah.
Delay my lord 28 days. Delay 28 days.
Let's see.
So
45.
Obliged.
Opposite part देखो तो Service elect.
It is returned, left without instruction. Returned, left.
376.
Press pursuant to the order dated 10/12/2022, or the notice although was issued to the opposite party, however, the same is returned with the postal remark.
Left without instruction.
Left without instruction. Let the notice on the opposite party be served through the IIC so and so form. Okay. No, this is a private complaint. Is it a private complaint?
It is a fair one, right?
Hmm?
A fair one.
Fair. No, where is it?
It is a fair one. Page 8, my lord.
Page 8.
37. Here, my lord, husband is forced to keep relationship with another man. That another man is before the law.
I see. Which police station?
Station, my lord.
Just be careful which file you are holding.
My son. Not careful. Rajpanika.
Rajkanika. Now I will have to tell you the party name also. No, otherwise- no. This is the which party, which item?
45.
40?
5.
5. 45. One.
ଶୁଣି ପାରିଲିନି ସେଦିନ ତ
45. Party name?
ବାବୁଲି
हाँ ठीक. Okay. Sir, हाँ ठीक.
46.
through ISC, my lord.
Through ISC.
My
Yes.
46.
46. Here, my lord, father of the principal accused has come before you.
No, what is this matter is about?
The compromise matter, my lord. Already principal
What
accused.
compromise matter? Just see, when the matter was taken up first, none appeared.
My lord.
It was urgent. Thereafter, I gave indulgence. Notice was issued, and now process fee is not filed. Pass over karo it go. Agar if it doesn't come in the second call, then I'll dispose it up. Okay. I don't think they are interested.
47.
46 appeared last time. Anybody appeared? Shashwati Senapati. Okay. 47. Okay. 47.
47.
47.
Matrimonial matter.
Notice.
It's not filed.
Pursuant to the order dated 25/11/2024, notice could not be served as the requisite is not 8.5. Or by way of last opportunity, the petitioner is directed to file the requisite within 2 days. If requisites are not filed within 2 days, the matter will be dismissed without reference to the court. If requisites filed, release the matter after 2 days. Peremptory order copy. Yes.
48.
I'm the petitioners in the first matter. So there are 4 matters tagged here. Notice was sent to OP2 informant, who's the Tahsildar in this case. But in the other 2 matters, your lordship, notice has been sufficiently
Same
given.
respondent.
Yes,
madam.
Same.
You are appealing.
Yes, madam. No, my lord. I'm in
Who
the
is appealing?
fourth petition.
You are
madam.
appealing.
The petitioners. Four matters are there, man.
No, then
I am
in 2
for-
matters, notice has not been served. In the 2 matters, notice has been served, but nobody appears, it seems.
Yes, ma'am.
Is there anybody appearing?
No.
48.
Nobody is appearing. जो मैटर सर्विस despite service, nobody entered appearance for opposite party number 2. When service
4341 and 4340.
we'll check it up. And then service direct first notice to be taken up by the petitioner on the opposite party number 2, entry mode to continue, release the matter. Yes. देखिए करो then service despite service, nobody entered appearance. Then service any press notice.
Because my lord, the persons are going to be retired in the month of March.
Yes, your lordship, a shorter date.
Sorted.
Grateful.
So April. April. 49. Service. Opposite party, 5.
22, madam.
5. Notice we issued to opposite number 5 by speed post also. Opposite number 5. Opposite for number 5 is important. Hmm?
25. Not at all.
Hmm?
Not at all.
The person to the order dated 3/1/2025. Has he filed the requisites?
Sir, notice is
Although the notice was issued to opposite party number 5, but no postal receipt has yet been received. Back, lease the matter on yes.
40, 50.
You know, the wrong defect is pointed about the registry, my lord. The defect is there shown, copy of charge sheet to be filed. It's not a case under CRPC, it's a case under section 7 of the EC Act. And peer cognizance taken on prosecution report.
Yeah.
Therefore, no charge sheet.
Peer report is there?
Peer report is there, madam.
Yes.
Peer report is there.
Ignore that. Let us come to the point. Yes. Ignore that. Let us come to the point.
Yes, ma'am. Yes. Can it taken up?
Okay. Let us consider the petitioner submits that the pointed out the wrong defect, which a wrong defect for filing the charge sheet. This case is arising out of two CC case on the basis of PR report, and charge sheet need not be filed. In view thereafter, the defect pointed out may be ignored, release the matter for hearing on request.
Fresh admissions.
Yes.
Yes. Tomorrow can
Not tomorrow. We'll adjust our list like that. Yes. We'll see how can we adjust. Yes. Other if you are ready to argue, I am ready.
Yes, I am ready to argue.
And then that's what I'm saying. Argue now.
Yes, ma'am.
That's what I'm saying.
Argue
on merits.
Yes, ma'am.
If you have a case, then we
See the page 26 is the current cognizance, my lord.
This is 50.
Page 26, my lord.
26, okay.
26
Yes.
is the order of cognizance, my lord.
Yes. Yeah, which you are challenging.
Yes, my lord.
Yes.
That is the impugned order. Just order number PR under section 7 of the Essential Commodity Act.
I read it. Come to PR. Come to PR. Where is the PR?
PR Annex 1, my lord.
Yes. Come to PR.
Annex 1.
Who are you? What is your name? Om Prakash,
There are
Sanjay, and Alok Agarwal.
Yes.
Come to PR report.
Yes, my lord.
Yes.
PR is Annex 1, my lord.
Yes.
There are PR, they submitted finding allegation on shortage of kerosene, my lord.
Yes.
There are two proceedings are initiated. One under section 7 for punishment, and another civil proceeding suspending my license. My license suspending, against that, I challenged and appeal before the government, my lord, on section clause 14 of the PDS. There, the London Appellate Authority found that there is no shortage. It was distributed to the.
Where is that finding?
Yes, my lord. You will see Annex of 3, page 27, staff, madam.
Show me that finding.
Yes. Well, also turn to page 31.
Yes.
Page 31, my lord.
31.
Yes.
Okay. Yes.
You also got it, man.
Yes, I will.
Second paragraph.
Yes.
In the above premises,
yes. Paper placed before
the papers placed before me transfers that the detected shortage of 12,738 liters of kerosene have actually been received by the concerned Gram Panchayats. That is Khaliapalli Gram Panchayat, Mayurdan Gram Panchayat, Malik Munda Gram Panchayat. The same has been delivered to the Gram Panchayat after due endorsement by the concerned inspector.
Next paragraph is important. I see no force on the submission of the licensing authority that there is a diversion of the shortest stop
Yes,
of so and so, so and so. Yes, what do you say? There is a finding.
The self-same allegation has been filed, my lord. Kindly glance page 34.
30?
34, my lord.
34, okay.
Already disposed of, my lord. That
Yes.
cognizance and approach to letter stage.
Yes.
Yes.
Page 34.
Yes,
The brief.
according to the permission from so. The plea in
Already they have challenged, my lord, and this honorable.
This case was earlier filed.
copy of the order.
Yes.
This honorable decline, my lord.
No, not.
Approach letter stage.
Number one stated they have said. Yes, what do you say?
Well, pursuant to this order, my lord, this case was earlier approached in that case, my lord.
Have you moved application?
My lord?
Have you moved an application? with
Yes,
the
I moved the application, they have rejected it.
Where is that?
My application Annex 5 and they have rejected Annex 6, page 37.
Yes.
There is no reason, nothing.
Where have you argued that point?
Yes, my lord.
It is 20. What is the shortage against the book?
Shortage 12,000. 12,748, my lord.
Subsidized kerosene oil has been, my lord.
My argument is first paragraph. The learned
But the appellate authority say that there is no this thing shortage. There is finding.
My lord,
What is the impact of that?
He has to challenge this order, my lord. My lord and senior has to challenge.
Yes, yes,
He
I challenge.
challenged it.
Yes, yes.
In this proceeding, he has challenged
Yes,
this order.
yes, I challenge.
What do you say?
I have to.
I'll just issue
My
notice.
lord, it
I'll
is
issue
the-
notice and say, because see, there is a finding of the licensing authority that there is no shortage.
If, my lord, if this should be the licensing authority order, they have challenged in appeal, is before the final PR, then it has to be quashed, my lord.
Same.
Otherwise, my lord, no additional evidence should be raised at the time of framing of that. That is the
Let us see the
because
licensing
there is
authority.
no mini trial, my lord.
Licensing authority just.
That is the, my lord.
I understand. Licensing authority order is dated 1/10/2015.
My lord. Here, my lord, your lord.
And the PR is.
My lord.
PR is.
My lord, read on, my lord, read on his Godam, my lord, 16/4/2020.
When the PR was filed.
Complaint was filed 3/6/2015, my lord. 3/6/15, 2015.
3/6/15.
My lord. And appeal file, my lord, 1/10/2015. After 4 months, my lord.
That is
My
that
lord,
is
my
that is then
My lord.
that's the reason the
My lord.
this
My
court said that
my
to raise all these
my
points.
lord,
He has
my-
raised these points.
My lord.
I
My lord, your lordship knows, my lord, no additional evidence at the time of framing, no mini trial.
Okay,
my lord.
I'll issue notice. Yeah, I'll issue notice.
My
Let the counsel for the petitioner submit that on the allegation that there is a diversion of 12748 liters of the kerosene. A prosecution has been lodged on the PR report dated on PR report dated where is that? What is the date? PR report dated 3/6/2015. Simultaneously, the license granted to the petitioner was also cancelled, which he had challenged before the appellate authority. The appellate authority, while deciding the appeal number 5 of 2015, inter alia has recorded the following finding. Para 32, page 32 also, 30,
31, page 31.
31 actually, in the above premises. Second para and third para. Second and third para. Correct. In view of the aforementioned finding of the appellate authority, then counsel for the petitioner submits that the prosecution lodged by the opposite party in 2 CC number 2 of 2015 is not sustainable. Issue notice to opposite party as so and so. In the meantime, proceeding before so and so is stayed. Okay.
51.
My lord, dispensing with a certified copy of the
criminal proceeding under Annexure 1.
Yes.
My lord, in this case,
IA number, IA for the reason stated in the application, IA is allowed, huh? And the certificate of dispensed with, yes.
my lord, this matter may be listed tomorrow, my lord. My lord,
Not tomorrow.
My lord, the urgency involved with this case.
Then argue it.
My lord.
Argue it, right?
My lord.
Yes.
My lord, the opposite party number 2 is the mother-in-law of the petitioner number 1.
Opposite party number 2 is the mother-in-law petitioner number 1.
1, Susmita Sethi.
Yes.
Opposite party number 2 filed DV case in the Lonent court below.
Mother-in-law has filed a DV case.
Mother-in-law. Mother-in-law filed against her daughter-in-law and all the family members of the daughter-in-law. But the daughter-in-law is residing at her parental house since 2013, being deserted by her husband or and
who is petitioner number 2?
Petition number 2 is
the husband of opposite party number 2.
Petition number 2 is father of the petition number 1.
Okay.
1. But petition number 3.
All are the family members of the petition number 1.
1. Family members and cousin brothers of the petitioner number 1 minor.
Okay.
The opposite party number 2 is residing in the district of Kendrapada. But the petition.
What are the allegations? Let us see. What are the allegations?
Your lordship kindly see the allegation. Allegation on torture, cruelty, maltreatment, ill treatment, and sexual harassment, so on and so forth. Your lordship kindly see.
The proceeding was initiated by the mother-in-law under section 12 before the learned SDJ, my lordship. And my lordship, notice to be issued to the.
Yeah, notice issue. What is the allegation?
That
petitioner number 1.
daughter-in-law tortured the mother-in-law. And for that, my lordship, already our DV proceeding was also, section 13 proceeding was already in the learned court below.
Which notice to opposite party?
Further proceeding.
Application will be moved for adjournment. Yes. Yes.
Challenge the cognizance order. That is Annexure 1 at page 16.
52, na? 52, yes. Notice? Okay, yes, sir.
I have challenged on 2 counts. Number 1, all the allegations alleged to have been caused at Hyderabad. And she has dragged, the informant has dragged to Berhampur jurisdiction by saying that she was not allowed to.
Nobody has entered appearance. That's right, service. Despite service, nobody has entered appearance for opposite party number 2. Let the service on opposite party number 2 be affected to the IIC. Which police station? IIC so
police station.
IIC Mahila PS.
Berhampur Mahila PS.
This is the matter also. Entry mode to continue. Matrimonial dispute research. Entry mode to continue. Yes.
53. 53, my lord, appearing on behalf of Miss Mahapatra. I'm on VC,
Yes.
my lord, may kindly grant a passover.
Passover.
54.
On accommodation should blend and
On behalf of Mr. Nilakanta advocate, adjournment is sought on personal ground. Release the matter.
entry order. There is an entry order. It continues.
These are interim orders are the biggest problem. 2016 interim order. Just imagine.
But I am appearing for the opposite party now. I am appearing for the opposite party number.
You don't have an objection.
Well,
You don't have an objection.
Well, it has, my name is wrongly reflected in the constitution.
Forget about small thing
Yes.
wrongly. You are there.
Actually, 130.
How do you know?
Well,
How do you know that matter is listed? Despite the fact that wrongly.
Wrongly mentioned, say, that's why.
So still you are there. So
Well,
talk about the matter, 2015 matter.
Yes, 1cc case, my lord. The check bounce matter, my lord.
And they have taken stay.
It recently got transferred to us, my lord.
Then
it just.
the 2016 138 matter stay granted and they are
It is recently transferred, my lord.
You are saying my name is not properly written. All these are the grounds. You should oppose and get this matter disposed of. What is this going on?
Today itself, the matter can be disposed of, your lordship. I'm reading, my lord.
He is asking for adjustment.
My lord. And then next week, your lordship.
Tomorrow? These are 2016 matter, 138 matter. What is this?
I have no bigger in accommodation.
Next week,
Next week, yes, sir.
Well, see, these matters are pending since 2016, and there is a stay operative in these. Stay of trial court proceeding has already been operative. The cases are arising out of a complaint, section 138 NIS, filed in the year of 2014. Keeping in view the urgency of the matter, released it on the next week, and made clear that no further adjournment shall be granted.
Yes, right.
If you seek adjournment, I will vacate the stay.
Yes, ma'am.
2014 138 case taken a stay and 1 decade.
Yes, sir.
And the statute says that it has to be done within 6 months. Unheard of.
55 minutes may kindly be taken up after lunch. Pass over.
Yes.
Yes, sir.
56. 57.
57.
Yes, 57.
56 declines. It is Arjun.
Yes, sir.
Married
56.
Arjun age. Married, you may kindly turn to page 14. Page 14, married annexure 1.
Annexure 1. Yes.
Married, I'm challenging this. I'm a retired government doctor, married in the ENT department. Married. I retired after attending the age of superannuation. Married, this is the summons. For the offenses, you will
page 14. Page 14, 1-4.
Page 1-4, madam. Annexure 1.
Yes. Yes.
Process, madam.
Yes.
The process I challenge as well the proceeding itself.
Appear before the court.
To appear before, as well as I am challenging the proceeding being without authority of law. So subsequently, madam. The offenses you will kindly see 312, 315, 316, 34 of IPC. Second part is 23, 25 of PNDT and 5, 3 and 4 of the MTP, medical termination pregnancy. So second part, 23 and 25 of the PNDT and section 5.3 are without the authority law, and this court had held it is quashed. Because for the competent authority has not lost the appeal, the complaint. So that part goes. I will show the judgment movements after. Now, so far as the 312, 315, 316, I have to place the matter before you. The whole allegation is, I am an ENT specialist. The allegation is that there was determination of sex and dealing with the gynae department, which I have no kind of nexus. I do not know ABC of gynae department. The allegation is,
and there are many doctors, the simple MBBS, they also do all these things. What to do?
No. That's a different
thing. You may be an eye specialist if you do determination.
This is
let us see the allegation.
Allegations.
Allegations are important.
Allegations, so far as me is concerned, there is no whisper of allegation against me that I have done any.
You are Dr. Anand.
Next page, you will kindly see FIR.
Yes. Now come to the charge sheet straight away.
2 lines before going to charge sheet, madam.
No, after investigation, charge sheet has been filed. Let us see what has been.
Charge sheet, madam.
Anand Chandro.
Page 33, you will kindly say.
30?
33.
33, yes.
This was the case registered on 22/7. the allegations are nothing against me, my lord. Nowhere. Only third paragraph, fourth line also. During investigation, it came to light that Navakrishna Sahu, son of so and so, has started nursing home named Krishna Clinic on the second floor of Arpana Complex, College Road, Noyagarh since 4 to 5 years. Srimati Sabita Sahu, wife of Navakrishna Sahu, is the proprietor. Kindly emphasize this word. Proprietor of nursing home. Thereafter, no allegation against me, my lord, in this entire charge sheet. Last page 34, you will kindly see. Only four of the accused persons were charge sheeted. Last paragraph, page 34.
Yes, madam.
Yes, my lordship. Kindly have a glance to page number 49, my lordship.
49.
Yes,
In the charge sheet, nothing is coming out
My
because
lordship.
the allegations are very, very serious and very heinous.
that's it, my lordship. Kindly have a glance to the page number 49.
49. If slightest link is there, I will not pass. Slightest
He
link.
is the partner of the Sabita Sahu, who is the proprietor of that clinic, my lordship.
Where is that?
My lordship, kindly have a glance to page number 49.
Yes.
Brief fact of the case in paragraph 4, my lordship. During investigation, it has been proved from the record that accused Srimati Sabita Sahu is the proprietor. Dr. Anandacharana Sadangi, the present petitioner, is the full-time partner, and Srimati Kettaki Dei is the staff nurse of the Krishna Clinic.
Yes.
Can it
It has also been well proved by
Dead body of small children.
Yes,
are dumped in all this.
only wrong and perverse I will demonstrate just
Very,
now.
very heinous.
Kindly see.
page number 38, ma'am.
38 out.
Yes.
Have you seen the allegations?
Yes.
Dead body of children. I don't know whether they are killed or what.
Yes, my lordship, there's a lot of dead bodies.
And on technicality, I will not.
No. I'm not. I'm married also, my lord. I'm married also.
My lordship, he was charged sheeted and released on bail on 29/1/2007.
Yes. What is that?
My lord, kindly turn to order number 11, dated 17th of February 2023.
Before this court?
Of this court, my lord. In this case. 17th of February, order number 11.
Order 11. Okay.
Mr. Mishra and counsel for the petition submits that the investigation was taken over by CIDCB as initially local police inquired into and submitted charge sheet, but not against the petitioner. However, despite having no material as he is an ENT specialist.
That is your submission.
No. Thereafter, let's see. My learned sister, what he is raising, that was questioned here. And charge sheet which was unjustified, not tenable in law. While claiming so, Mr. Mishra and counsel for the petitioner refers to statement of Dr. Bhuvaneshwar Shukla recorded under 161 by the IO, satisfy the court that it runs contrary to statement of the said witness before the local police. In response to above, Mr. Mishra and counsel for the opposite party submits that he needs to go through the case diary and also verify the statement of the said witness of the local police and also CIDCP, and also find out whether the petitioner to be partner or joint proprietor of the alleged clinic and respond back.
Yes.
Now, from the records itself, I will show the, kindly see the charge sheeted document, my lord. That is at page
Yes.
24.
24.
24, my lord. The part of the charge sheet. The, my lord, serial number 2.
24. Yes.
24 charge sheet serial number 1 sale deed, bhai number so and so, sold by Narsinga Vishwala to Sabita Sahu.
That is the
No,
land is in the name of Sabita.
Next part,
Yes.
the
He is not a doctor. That means you are doing everything.
no, my lord. See, he,
No, will not.
One also,
Yes.
during further
Yes.
investigation, all the accused name was there, my lord. In page number 51.
Yes. Yes, sir. What do you-
my lord, kindly see the document of ownership, whether I am a partner or not. That's the only thing.
But there
The
the business was-
statement
those things will be at the appropriate stage. It will be looked into whether you are partner, you are not partner. And if the charge sheet has been filed and charge sheet is said that you are the partner, and where this kind of things are happening, child bodies are dumped in pit.
charge is heinous and crime, but I have no nexus with them.
Yes, my lord.
That nexus will be decided. Nexus is established on the charge sheet, saying that you are the partner of the same clinic from where the children were taken and dumped in the polythenes and all.
In page number 51, it written, my lord, sir, during further investigation, accused person, Dr. Navakrishna Sahu, Dr. Anandacharan Sadangi, partner. In the
Partner.
bracket, it was written partner.
Huh.
And Dr. Aurobindo Map, all are the accused, my lordship. In the next paragraph, it was written that all are the accused, my lordship.
Where are you reading?
Page number 51.
51. Yes. Yes, sir.
In the first paragraph. During further investigation, accused person, Dr. Navakrishna Sahu, Dr. Anandacharan Sadangi, partner, Dr. Aurobindo Mahapatra, ONG, Dr. Lakshmi Narayan Bisway Surgery, Dr. Surendra Kumar Sadangi, ONG, Dr. Prafula Kumar Samal, Anesthesia, Srimati Ketaki Dei, Nurse, Ruma Dei, Nurse, Puspanjali Pradhan, Nurse, Chumati Rama Naik, Sweeper, who used to take that fetus, my lordship, to dump, the sweeper. Surrender before the honorable court in
See,
this case.
the attendant and peon and everything is carrying in the polythene the fetus of the small children and dumping it without the knowing the doctors and partners. All are mixed up.
Yes.
My lord,
All are mixed up.
you kindly
You
see.
can't afford to, quash the proceeding at this stage.
11
Madam,
accused persons
Simply.
there.
Yes.
Used to do this.
Yes. Yes.
No,
Yes.
the statement is itself is perverse according to me. There is no either partnership or any kind of material to show that I am the partner of that clinic. The owner himself says, he Navakrishna Sahu, he is the doctor and he was holding and doing all these things.
I will not appreciate at this stage. Only charge sheet has been filed.
Charge sheet has been filed.
Why should I appreciate everything at this stage?
No,
Viewing the gravamen of the allegations.
my submission is that even a straight statement by the police without any material record, this honorable court can do.
Anyway, once
I show my lord a judgment to that effect. You also may kindly put it.
I reserve the judgment. You show whatever. Yeah, reserve. Huh? Give
Madam,
rating subject.
Madam, for a moment, you also may kindly see the statement of Sabita Sahu.
Okay. Sabita Sahu.
Sahu.
Okay. Pace, sir.
That is not annexed, madam. It is a part of charge sheet. Part of charge sheet.
Sabita Sahu is one of the accused with you.
The accused, he said.
One of the accused with you, who is a partner. She is the owner without having license, without having, and you are operating behind. That is the allegation against you. And it has to be looked into. I give you the liberty, move application and argue before the trial court.
Before framing of charge.
Yes, that's the better idea because everything will be there. I'll not interfere, but I'll give that liberty. That's the better idea because everything will be there. You argue all these things. And this same.
So far as the offense part, the without sanction.
According to me, this is my suggestion. If you want me to write a order, I'll write, and
No.
option is also goes.
No.
Better that you try some because see, allegations are so serious. Once you read it, you will not touch the file, and it is only charge sheet has been filed. You just see your conscience will permit if these kind of allegations are there.
My lord, you're throwing the ball on me.
See, the due process has to be taken care of. Therefore, I am giving you liberty, you do it. Otherwise, I will have to write everything. And you are right to, at the charge stage also you can be discharged.
I will file a discharge application.
That's a better idea. That's a better idea. You do it. I will not prejudice you by writing anything.
All right. My lord, the PNDT and MTP, that part has been
You
passed.
rely upon the NILA to deal with it. Just think
All
about
right.
it.
Your Honor, observe that
I will not say anything. I'll simply you withdraw and move application. Otherwise, the moment I'll have to go into the merit, I have to write something which may prejudice you while moving application. It's better that you go with a clean, hand and argue everything. Everything is open to you. That's a better idea. Think over.
Right. I will move the discharge application.
Item number 58.
Let me come to this.
Adjourned by the interim order was that, it's a pattern.
Interim order is there, then it will continue. Don't worry.
Continue. The pattern matter,
Yes, I will move the
Yes,
discharge application.
Yes. Mr. Misal and counsel for the petitioner after arguing at length submits that since the charge sheet is only filed, and charge has not been 20, as Edwin failed, he would prefer to move an application for discharge and urge all the points as has been heard in this petition. With this liberty, he seeks to withdraw the petition. Then the petition is disposed of with liberty as well.
My lord, with your lordship permission, item 68. My lord, it has become infructuous. Lordship may.
No, this is the best thing one can do. Infructuous. 68.
Item 60, my lord.
60, yeah.
Lordship director in complainants appeared before this report. After settled compromise.
I'll take it up at 2 o'clock. No, yes. Any mentioning for any adjournment or anything?
Okay, I'll go.
Time to the court. Where have you said what is the allegation? Show me the allegation. Where have you said?
My lord, at para 2, my lord.
Do you have the complaint copy? Do you have the complaint copy?
But I am not carrying, my lord, today just complaint case because of village dispute, all the 3 cases posted, my lord.
The second matter, at least do you have a complaint copy? Say that. Same. Here also same. It is less than half a page. Not even half a page. There are 6 lines here. There are 9 lines. Here 6 lines.
My lord, sorry, I faced this problem for the first time, my lord.
How can see the right? Just see the offences. Offences are serious. Court is not even entitled to know what is the allegation. And this much order is passed or filed, and I say that I have compromised. You kill someone and say that compromise.
So, my lord,
And quash it.
this case placed before your lordship many times. I could not able to face such problems.
I also could not see that. That is the reason this matter will take less than a half a second to dispose of. And because if you the way you have filed the petition, that is why 5-6 adjournment I have given.
Origin case already passed, my lord, your lordship was.
Show me the original case. What are the allegations?
Original case, my lord, may I?
At least,
yes,
at
my
least
lord.
bring that on record.
Yes. My lord.
You file all these documents. Then counsel for the petitioner seeks an adjournment to place on record all relevant documents to substantiate the case, release the matter.
Their personal evidence can be dismissed.
No, I will not do it. You have to deal with it. See the allegations, just see the offense.
My lord,
Explosive Act, Arms Act, and all the offences, and IPC.
My lord, kindly, I am carrying original case record, my lord. Your lordship kindly see.
No, I will not do that. Let it be. You have to suffer for the way you conduct the case. What is this?
Well, that is the written report, my lord. That case.
But how will I correlate? This case is related to that case. How will I?
Yes, my lord. This case is related to this case, my lord.
Because you are saying. How will I relate it? 3 cases you have filed. How will I relate this case with this?
That is the preliminary case.
Where have you
That
said
case
that?
registered.
Where have you said that this is a FIR registered? You show me. In the petition, where have you said? 2-page petition. Half a page impugn order. Except that nothing. Where have you said that this is a case registered and FIR number so and so, which has been quashed? Where have you said? This FIR is?
Lordship earlier directed to take in.
55 of 2002.
My lord.
In the petition, where have you said? Where have you said?
My lord, kindly see page para 2 of the CRMC petition number
Oh, no,
49.
not like that, sir, please. See, 6-page petition. Till 4 page, only cause title, name of the petitioner. And 2 pages petition. Let's see your petition.
Absolutely.
Till 4 page, only the cause title. And 5 and 6, there are 2 pages petition. And out in page 6, half a page is only the prayer. April to the don't discuss this to the people. Place it after a week, or 18th or 19th. Place it all. 18th or 19th.
In the meantime, not to take any coercive action.
No. I was thinking of imposing at least 1 lakh of rupees cost and dismiss this petition. 1 lakh rupees cost. But 4 people, I have seen them, therefore I am leaving. Yes. Don't do disservice to the court and to the clients also. Don't do that. At least you should make some averment. Some, what are the allegations? What is the complaint? 2-page petition and quash it. How can I quash it? Just imagine, it's a court of record. Try to appreciate. If I quash it, it has a serious consequences. Offences are serious offences. And the court has taken cognizance of those offences. If cognizance would not have been taken, I can understand. Cognizance is taken by a competent court. IPC offense, Arms Act, Explosive Act, all offences, cognizance has been taken. Unless I see what are the allegations, how can I quash a cognizance order like this? Without seeing the complaint copy, without seeing 202 statement, without anything, how can I do it? Try to appreciate. I can't, nothing to be sorry about it, but
because
I am rather sorry that you have filed this kind of.
Because your lordship
put it on 19th. Huh? If I bring everything on record, I'll do it. Okay.
75.
I'll do it on 19th. Huh? Bring everything on record. Don't leave it like that. Let them come. I don't know. I'll have to maybe have to ask the question. We don't know. Let them come. Shall I fix it at 2 o'clock so that I'll fix it at 2 on 19th at 2 o'clock. So that they need not come in the morning. Okay. Okay. And make the petition also, you have to tell what are the allegations.
In the way of additional affidavit.
Yes.
My lord.
Yes.
Adjourned to one document says.
Yes, my lordship, I have talked that, my lordship. Now what happened, her husband has been left her. And because of this reason, my lordship. And no one, she is staying alone. And she want to compromise because she doesn't want, because this person has already married.
who this accused.
Yes, my lord.
And she has also got married.
Yes, yes.
But because of this reason, her husband left it.
That he has also married another.
That part. She
That is
didn't
now
tell
she is
me.
alone. That is why he is because of to settle the matter.
See the
Because
plight of this woman. That also you
that
have to
is
appreciate.
That is valid. That is why probably
Today she is giving consent because of this case.
yes,
She has been deserted by her husband.
Yes,
Yes,
her husband deserted and married to another lady. Now she is probably she for future. She doesn't want to.
What future she has now?
Okay. He has to go ahead because her husband is has left.
Oh, okay. How much
That-
cost you will pay to her?
Pardon?
You have to pay cost to her.
Kete
You can't leave the 376
That-
case. Otherwise, I will not touch it.
As your lordship-
376 I should not cost.
So that as your lordship.
See the
that
plight
is
of this
okay.
woman. See the plight of this woman.
That as your lordship.
She has been subjected to this cruelty.
My lord.
And fortunately or unfortunately, she married to someone else. And
At the time of occurrence or they have.
okay, but that
The vehicularship, the release of the vehicularship, petition the owner of the vehicle and not name the vehicularship. And let's say I have filed the documents in the IA number 3153, which is last week in lordship 3153.
Yes.
And that is the RC particulars of the vehicle and the suit of partnership. Petitioner and the vehicle is in still custody. Lordship 5/10/23 lordship. It is more than 1 year. The vehicle is lying in the police station.
You are the accused in that case.
No, lordship. I am not accused.
You are an accused.
I am the owner of the vehicle.
I'll just issue notice. Just check it up. Issue notice. 457 application. Yes. Yes.
Lordship.
May I please your lordship, my lord?
Yes.
My lord, I filed this application for question of the entire posting, my lord.
Yes.
But with fair item, my lord, that will not sustain. But here, my lord, the petitioner has been was released on bail, my lord, on arrest, my lord, that is 294, 394, 341, 506, my lord, IPC, my lord. Subsequently, the charge sheet was submitted that 364A was added, my lord. That is why, my lord, your lordship will protect me, then otherwise, my lord.
Sushila Agrawal.
Pradeep Ram versus State of Jharkhand.
Should give. And Sushila Agrawal also. He is already on bail.
If the higher offense, my lord.
Higher offense is added, then
He has to approve
court has to. Yes. Well, which paragraph?
Last term, your lordship.
Which last term?
My lord, higher offense is added, my lord.
He has to approach that court.
He has to approve that court.
Trial court. After getting.
You can approach.
I'll approach.
7 disposal we got facing for a magistrate.
Petitioner
Taking note of
petitioner is accused in FIR number so and so. Allegation is given. After investigation, charge sheet has been filed. In the present case on 31/3/2021, aiding a graver offense of 364 capital. The petitioner has been on bail. However, after the addition of the graver offense under 364 capital A, petitioner apprehends that once he appears before court, he may be sent to prison.
Other offense are 364 খালি add হয়েছে other offense are আছে
The apprehension is unfounded. At the same time, petitioner submits that he would be appearing before the court on or before 10th of March, 10th of March also, and move appropriate application for grant of bail. Grant of bail. So such application is moved, same shall be considered in the light of the judgment in Sushila Agrawal and Pradeep Ram. Pradeep Ram. Till then,
take note of the fact that I have not misused any liberty granted by me. That is the,
obviously,
if that will be
all
that
the
will added.
all the grounds petition open for the petitioner to urge before the court. Yes. Dispute.
May I please.
This case, my lord. Petitioner seeks to challenge the order dated, my lord, 8/11/2005, my lord, thereby taking cognizance on
11.
11. 8/11/2025 cognizance taken, my lord.
25 or 5?
205, my lord.
205 today cognizance.
My lord, what happened in the meantime, my lord? Petitioner, my lord, during course of investigation, he was arrested and released on bail. Subsequently, my lord, he came to know that one of the co-accused, my lord, he filed for the application before this court in respect of the co-accused who confessed the name of the petitioner. The case has been quashed against the co-accused, my lord. Only, my lord, the petitioner and another co-accused.
What is the stage?
Stage, my lord, though the trial has not been concluded, my lord. And
No, stay. Concluded is something different.
No, my lord.
If the witnesses have already said anything against you, then
Since
the trial court will take care of it.
I 2024, I have to take instruction of how many witnesses, my lord.
Right on. The petitioner in this petition has challenged the order dated 8/11/2005 passed by learned SCJM Jharsuguda, whereby the cognizance of offences punishable under section, what are the
489B, 489C, 34 IPC.
34 IPC has been taken against him. Mr. Raghuda, learned counsel for the petitioner submits that the petitioner has been entangled in the case on the basis of the statement of co-accused person. He submits that the co-accused persons have approached this court for question.
One of the co-accused.
One of the co-accused.
Dibakar Naik.
Dibakar Naik approached this court.
CRMC number 3929.
3929 approved for 2011. The court has already quashed the prosecution against him. Relying upon the said judgment dated 26/4/2012 passed by this court in CRLMC number 3939 of 2011. He seeks indulgence of this court for quashing of the criminal prosecution initiated by this him. And Mr. Raghuda is not able to ascertain regarding the stage of the trial in the present case for the present petitioner and seeks an adjournment to ascertain the state. This is the matter after submission.
One
In the meantime, the issue notice. You also. 2012 order. 2005 cognizance is taken. Today you are coming after 2 decades.
No, my lord, we are filed 2024, my lord. Since I am that side one for that, could not be taken.
24 also after how many years? Just see, 12 years.
My lord, when they came to know
that. Why now you might have been convicted or something might have happened.
No, my lord.
Just see, if at the fake end, then
my instance earlier 2024, my lord, trial has not been started by the when the case was filed.
Irrespective of the fact that the co-accused
in the earlier
has
case,
been allowed.
in the earlier case, it has been held that that person is a witness.
Whatever, irrespective of that, even if
finding that
it is quashed,
who's against
if the evidence has come, if the evidence has come on record, I can't quash it.
Against whom against the case quashed, my lord, he is the principal accused, my lord. He was the principal accused.
But the court said that he is a witness.
No, instead of citing him witness, the IO cited as the accused.
Anyway, if trial has already commenced, you just see the evidence.
But when the case is filed, my lord, by the time none of the witness examined. In the meantime, 1 year left for that. I don't take it.
Okay.
Please, this is a case where the petitioner and the opposite partner one constructed a farm and running their business at Raulkela. When the husband of petitioner was serving as the steel plant manager. Due to his mental imbalance, left this job. Wherever she has gone, he has now absconded. And they stopped the business. During the business, therefore, the opposite partner one supplied some papers against that 3 lakhs, as per their claim, 3 lakhs are there. And they have the jointly, opposite partner 4 and the petitioner given a joint check of 3 lakhs. That was degenerate. That the case was filed before the Raulkela court in one's complaint case number in 2012 of 2020. Thereafter, the notice was served to the petitioner number 1 in the father's house and received the notice on 17. After receiving the notice, they go there. The matter was compromised. Out of 3 lakhs total amount, that was out of settlement 1 lakh 150 in his share and 20,000 to a litigation 170 paid. your lordship shall look to the page 12, starts from page 12. The receipts, the amounts are paid through DDs. And the receipts are there. First one receipt that out of the settlement, 50,000 advance I received on 16/7/2017 by 2 DDs. Thereafter, the memo was given and DDs are there also in page 14, 2 DDs. Thereafter, the final settlement out of 120 was paid on 13/9/2017.
Yes.
And that is by DDs also, the DDs are there
Yes,
in page 17.
What happened there?
And in that they have also given a memo that I will file a memo and I will file memo before this lower trial court and the complaint will be dismissed against you. But subsequently, after 2024, another notice has come. That is, I have annexed page 8. Accused number, page starts from page 17. That is another notice was served fixing date of November 2024. After the payment of all these things, taking all the and giving a receipt, and memo was filed to.
Where is that summon?
17, yes. Page 17, very late.
Page 7, not 17.
7.
7.
This is the complaint number?
212.
Where is that complaint number? Show me. Yes, at the top.
16212.
Top. Right.
Yes.
Petitioner is accused in the ICC case number 212 of 2012. When the matter was in the year when on 17/6/2017, when the trial was going on, at that stage the parties have settled the dispute pursuant thereto. How much you paid total?
170 total. 1,70,000.
1,70,000 has been paid towards full and final settlement. Settlement. The check, LA check amount is 3 lakh. 3 lakh. The petitioner has relied upon the money receipt issued money received dated 17/6/2017 at placed in annex 2 to this petition. He submits that despite the settlement, the opposite party number 2 has not withdrawn the complaint case. Therefore, a fresh summon has been received by his client on.
The fixing the summon was that was sent on 23rd September 2024,
23rd September.
fixing the date of 5th November 2024.
Summon dated 23/9/2024, fixing the date of hearing to 5/11/2024. 24. Issue notice to the party looking on so and in the meantime proceeding before where is that proceeding?
212 of 2020.
See, November 2024.
One CC case now 212/2.
What is happening now? You have not gone there.
No, after that, I have sent on advocate. He has taken one time only. That's not.
Simply issue notice. Okay.
That is stay proceeding.
Proceeding before so and so in so and so state. Yes. You have paid. The receipt is there. Yes.
Urgent copy.
46.
No, counsel is not here, my lord. The father of the principal accused, already against the principal accused, case has been quashed.
Non-appeared. Same.
It is adjournment. Adjournal, right?
But service complete. The matter was taken up on 7/8/2024. None had appeared for the petition. In the interest of justice, matter was adjourned to 21/8/2024. Subsequently, again, the matter was taken up on 4/12/2024, and notice was issued to the opposite party number 2. However, the counsel for the petitioner has not filed requisites for the notice on opposite party number 2. in view thereof, it appears that the petitioner is not interested to proceed with the present matter, hence the petition is dismissed. Yes. None appeared for the petitions today and even on second call.
Lordship, kindly take a next week on behalf of Ms. Deepali Mitra.
Yes.
Lordship, kindly take a next week, Lordship, on behalf of Miss Deepali Mahapatra. Lordship.
Interim order is there.
Yes,
2017.
Lordship.
What is this case? Facts also. You don't know. Do we have the file or not?
No, Lordship, no, Lordship. Just.
Why are you accepting this kind of request without knowing anything? Suppose if I'll pass some order, it will come in your. There is an interim order operating from 2017. And every time the adjournment is sought on one pretext or the other. Today you will come, somebody else will come next time. I am passing it over, otherwise I'll pass some peremptory order. I'll pass some peremptory. Right. The present case, in the present case, the interim order dated 11/8/2017 is operative. The matter is urgent time to time. The learned counsel for the petitioner. What is your name?
Vishwaranjan Swain.
Mr. Vishwaranjan Swain, on behalf of Mrs. Deepali Mahapatra, it's an adjournment on the personal difficulty grounds. By way of last opportunity, one adjournment is given. It is made clear that no further adjournments shall be granted on the next date of hearing.
Interim order 2 weeks. See, interim order may continue.
Interim order. Yes. You know only one thing, that there is an interim order. Go and get an adjournment and ask for an extension of interim order. This much instruction is given to you. Isn't it?
Yes.
Yes.
55.
May I please, Your Lordship? Lordship, this is that matter that the bank officers have been made in the complaint case made accused. The Lordship had directed to take instruction to my state council.
Last time, yes. Please,
No, criminal incident. Stage of investigation.
Status of the investigation. Yes. Status of the investigation.
Investigation is still going.
And the complainant is yet to be examined.
By the police. 161 statement.
And the complainant has yet to pay any money to the bank also.
See, if you are saying this, advancing money through nationalized bank is a promotional activity of the government. But these people, those who are serving in the bank, they have strangulating.
What is the allegation?
Yes. Let me paraphrase, instead of going, I'm a small entrepreneur. I was advanced with.
I mean, there are many petitioners.
So far as the complainant, I'm the complainant.
Okay,
I'm the complainant. Opposite part number 3. I took the loan.
Mitra Mishra.
Yes, I took the loan for establishing a aspic industry. There are two components of the loan, my lord. One is the machinery and the second one is the superstructure. I have given sufficient mortgage for the loan to secure it. Now, for the superstructure, they have advanced the money. I have started constructing. So far as machinery is concerned, it was not available in neither Odisha nor in Eastern India. I got information, got the quotation from a farm of Rajasthan and submitted before the bank. Bank went for its internal assessment or something, survey, something like that. That report says you can give 10% advance to the supplier and 90% on delivery. Here, what the bank has done, given 100% to the supplier. For 2 years, he didn't supply nor responded. Thereafter, I initiated a proceeding to at least recover the money and other things.
From the Rajasthan guy.
Rajasthan. Behind the back, what most effort I must have, that is not record, your lordship can imagine. He was arrested from Rajasthan and produced before the Orissa court. He remained around 1.5 months in the custody. Thereafter, he returned the money
on your FIR.
On my FIR. Returned the entire money with interest to the bank. Now, what the bank has done, bank has adjusted the entire amount towards my loan. There is no missing. I could not start my production, superstructure, and I am having the loan. Now, instead of promoting my business, you are strangulating me. This is one aspect. Second aspect, my civil score gets so poor. No one is looking at my face.
Then who are the petitioners?
These are the bank officers, those who are instead of their surveyor report.
You filed a criminal case against?
Yes, complaint case. Since the police case is only confined to
what are your allegations? All these things.
Allegation are these person define.
File a damage suit.
So far as damage suit, my lord, so far as the criminal.
What is criminality about it?
Criminality, my lord, here instead of they are discharging public duty, they have with them their own assessment or their own report. How can they defy and cause loss to someone who I am also a citizen? I need to be protected by their action.
Now, what is the criminality in it?
And they here what they have challenged. They have challenged the complaint petition doesn't contain affidavit and it requires sanction. These 2 points. So far as sanction is concerned, it is misconceived.
You file a damage suit against them. They have.
But can it be a ground to quash this? At the 156 level, my lord, they says these are the 2 grounds. The foreign ground would be that it is not.
On merits also. Where is the complaint? Where is the complaint?
Starts from page 22, Your Lordship.
22. Okay. 22.
Allegation is broadly at
yes, no, it's all right.
And
we
both the husband and wife on deathbed, asking us, my lord, that course is open for us. The wife is suffering, the loanee is suffering.
This may be a misconduct on the part of the bank officer.
Misconduct that they will look into other aspects. So far as the criminality is concerned, let it be considered because the court below, while referring.
What are the offences?
Offences 420. 120B.
What is where is the entrustment?
So far as the entrustment is, if they are involved in a practice.
If the money is only sanctioned, where it has not been disbursed to you. Had it been disbursed to you, thereafter it was transferred, then the entrustment. Bank money has gone to someone else.
No.
And they are being prosecuted.
No.
And all these.
I could not convey. Your Lordship may re-appreciate. I am putting in this way. Madam, that amount which was given to the supplier is for the machinery to be supplied by me so that I can start production and repay the loan. Here what has happened, you could have paid 10% to them after.
I understand it. Facts I understood. But I am just wondering all these things, banking transactions, all these banking transactions. I know, see, people. The bank is always notorious that they offer the umbrella when there is no rain. When the rain starts, they'll take back the umbrella. This is their style.
My property.
And they will be after your life. Take loan.
That's why
when they give you loan, when you require the money, that time they shall not disperse.
That's why I say that there's.
This is but where is the criminality?
And so far as the secured asset is concerned, it is huge. I'm really
all these things are just civil dispute.
Can be looked into. You'll also may see the 156 order. How can at this stage we said that it is not made out?
These petitioners were officers of the bank.
Yes, my lord.
Who are they?
They are involved with the transaction. They are involved with the transaction. That's why the London magistrate said.
I think you are stretching too far.
My lord.
You are stretching too far.
Stretching too far, my lord.
May I understand your ordeal, but that doesn't mean that.
Should I say my bottom line, my lord? Subject to your lordship. My lord, I am interested to square up the loan because at any moment we may die. We do not want to leave the burden of civil liability to our children.
So then now, you are admitting that you have adopted an arm twisting method to get it.
I have to. And secondly, my kids are staying abroad. They are interested to wipe out the loan.
Why don't you? Your officers have been
yesterday.
See, fact of the matter is, You people have done this mischief.
No, not mischief. Please, your lordship may kindly come to page 47, your lordship.
47.
Yes. Sir, please, now.
47.
Has
he given you the?
Yes. Page 47, authority has been given to pay not to 10%, the whole amount.
To me.
Yes. Page 47, it is their letter. Says, para 3, your lordship. Secondly, the supplier.
Yes.
Supplier.
Para 3, third ground.
47. Yes. Secondly, the paragraph before that. The LMP, Rajasthan has submitted fresh quotation to revalidate the offer.
Read the relevant part.
Yes. We have deposited 2 lakh rupees to the manufacturer of machines for our dynamic. Now you are requested to contact the manufacturer and to balance their CA, which they are furnished. The next page, your lordship, kindly come. List of supplies or put to contractors. This is the list of supplies that they have.
The part of that letter.
Yes, part of that letter.
Yes.
1. That is that form, your lordship. That company who was supposed to give that.
RK Enterprise.
Yes, the whole amount was given, not 10%. Your lordship.
4 lakh 20.
No. Bank contribution is 20 lakhs 74. Proprietor contribution is 6 lakhs 91.
Yes.
So he has requested to pay the whole amount of 26, not 10%, as has been propagated by my learned friend. Now the next page, your lordship. This is an affidavit after default. The affidavit shown by the complainant. Para 2, that you have availed so and so rupees, and out of the availed of 2 crore rupees from Dina Bank, rupees 27, only including my share towards purchase of fully automated so and so, went to dispute due to fraudulent nature of supplier so and so. However, I am associated my sister concern, which are capable of paying interest as well as capital in time from their sources.
Yes,
so there is no risk.
Yes,
So they have admitted
these. That is what your lordship has already said. This is arm twisting. Your lordship may see. I have annexed their internal assets.
You can't use they are proceeding like this.
Can they act on my instruction?
Get the instruction.
Can they act?
I was just wondering.
Your lordship see the affidavit I have filed. Your lordship may see the affidavit. It is the bank document.
So I think the criminal proceedings are not decided on the basis of affidavit filed at this stage. Investigation is going on.
That is what
I will take into consideration your affidavit and decide.
No. That is what I am saying, my lord. Why at this?
You go and tell everything to the IO. I will dispose it up. IO will take care and conclude the.
Instead of that, what your lordship was asking little earlier, take instruction. I'm
not that.
Running away. I'm interested.
No, this is not the forum, your lordship. I'm here.
This is what.
No.
Let's come to see. Forget about the technical.
Yes, my lord.
Your officers are in this.
Yes, your lordship.
There is something has gone wrong. What is the proposal? What is the due amount? You tell me.
He is not aware of that. What is the OTS?
One minute.
What is the OTS? What is the OTS that he is proposing?
Will you give the OTS?
Yes,
no,
my
it
lord.
is.
Yes, my lord.
Proceedings are pending before the DRTO. Let me approach there. Can it be done here? Proceedings are pending.
You are right. Then.
And had it been a case, but please let me complete.
I think I can't. You don't want to.
No, I am not there, your lordship. Had it been a case where DRT proceedings were not there, then things are different, your lordship. I could have assisted, your lordship. There is a proceedings pending before the DRT for the self-same cures. How can that be bypassed?
Simply urgent to.
And in that, one more thing, my lord. It is said 197 is the bar.
All these things in the investigation stage, I am not going to enter in.
That is what I am saying, my lord. That is what.
I will. Give it to me. I will dispose it up.
4 years, my lord.
Before
I'll give it.
Take little pain. Let them.
I'll dispose it up.
One case I have been relying on also. Priyanka Srivastava, it is not only considered, it is not aspect of affidavit only, your lordship. The broader picture by the Honorable Justice Deepak Mishra has said that similar facts, your lordship. Similar facts, I have, para 19, I have.
Which point? Let the investigation go on.
Yes.
Not the stage. Let the investigation go on and tell whatever you want to tell. Tell
this is what is the magistrate should have done before giving it for investigation.
No. It's a misconceived.
Let me complete. No, this is not fair on my part. On his part, your lordship.
It's unfair because you are citing a decision which is not applicable.
Let me. I'll pass the order. I know.
My lord, please.
I understand it. I know both the
judgment. Then your lordship may pass you. Kindly bear with me one moment, your lordship. Para 19.
Yeah, you people are making a constitutional issue.
No.
Matter. I am trying to find out way out.
I'm not, no, I'm
That is
there.
the issue.
I'm trying.
It take two seconds.
I'm not there to disturb your lordship. Only one.
You can't waste half an
Only one paragraph I'll show you.
Which paragraph?
Para 19, page 13, internal page 30.
Yes.
7. Internal page.
We have narrated the facts.
Yes, we
Yes.
have narrated the facts. Similar facts is there, your lordship. Then your lordship may kindly jump to page 11, para 27 and 28.
Yes.
These three paragraphs, your lordship may kindly
27,
28, 19, 27, and 28.
Yes.
Priyanka Srivastav.
Yes.
But I have given
So
a.
I don't want to, your lordship, while you detect that, your lordship may kindly consider these three paragraphs. And also para 32, your lordship. 33, wherein section 32 has been taken care of surface.
32.
Of surface area has been taken para 33. Your lordship.
Yes.
The other decision of 2023.
30?
It is a decision of the latest decision.
Which paragraph?
My lord, paragraph. The court has posed a question, your lordship, internal page 14. Para 37.
Yes.
1 and 2.
197. Not relevant.
Now the court has answered, these persons being the officer who can be removed without interference of the government, which is the first requisite of section 197.
I'm not there, your lordship. Section, this is not applicable, your lordship. Section 197 is for cited.
You have cited a decision last day.
Specific.
Yes.
Suffice Act, specific act is there, your lordship, protecting the officers under section 32.
Those
Under that,
abhorrent
this-
assertion,
Those under that,
absolutely not there.
Priyanka Srivastav is there.
Yes.
Not a word whispered in this application. May not.
Law is there. You need not plead law.
Yes. Which paragraph?
Date that I have.
37 only.
37. If without pleading something can be said and answer is not required, then why should we are here?
Your lordship, I am punishing a date chart for your lordship's convenience.
Yes.
And they copy it.
Yes.
59.
What date? Grateful.
Date chart?
तो चाहिए अपन कितना अधिक रखते
मैं दबुनी छाड़न रात्रि रिक्वेस्ट करछन रिफ्यूज कला पर यू आर एग्री प्लीज हेल्प मी फॉर माय पेक्यूनियर इंटरेस्ट दैट वाज आई वाज रिफ्यूज्ड yesterday night. That's
My lord.
Yes.
Lord, on behalf of Mr. Babuna Das Madhu, my lord. My lord, this is a family matter, dispute between husband and wife. And my lord, divorce has been completed between the parties, and the opposite party has already taken the alimony from the petitioner.
Yes. Service have you? Huh? No. Through IIC.
Notice has been issued, my lord. I repeat.
I know. Last order is through IIC. The opposite party number 2 was supposed to.
I repeated notice has been issued.
Service complete. Yes. Received also. It is not coming forward. Show me now. Judgment. This is he has received the. Where is the settlement terms? Is it reflecting in the judgment?
Yes, my lord. Judgment, my lord, 26, page number 26. 26.
Which part of the order?
My lord, page number 31, para number 9.
Chief. That received.
This is not appearing also before the learned court below.
Marriage is resolved and 4 lakh rupees has been paid. What are the offences? Where is the settlement term? Has she said that I will withdraw the cases or anything of that sort?
No, my lord, but opposite party is not appearing before the learned court below.
And I can see that. This is a contested petition, huh? Decree of divorce is granted on contest. Have you read the file?
My lord.
Have you read the file or I'll read it for you?
My lord.
Have you read it?
Yes, my lord.
Come to the page 34, para 6. Madam, what is the instance of opposite?
That taking impossibility of reunion into account, we both the spouse decided
Okay, I
to.
read it for you. Thank you. I read it for you. You should have read it.
My lord.
This is your case. I don't know, the instance of opposite party number 2, FIR number so came to reach against the petitioner, against the petitioner and so on so. On the ground of settlement, the petitioner is seeking question of the present FIR. Where is the petitioner?
Petition not come.
You bring the petitioner at least.
My lord, actually matter बहुत थोड़ा list हुए पढ़ने में petition पूर्व थोड़ा बहुत थोड़ा appear है चीजें तो आज तक ठीक
He
असुविधा
is not doing any grace to the court. He has to appear. He is an accused. Complainant has not come. It's all right. I will take note of that. But the petitioner has to be there. Tomorrow. I'll dictate the order.
My lord.
Tomorrow you bring it. Huh? Day after tomorrow. I'm dictating the order because I've read it. No, I've read it. What call it?
Day.
The matter was taken up for hearing on 20th of August 2024. A notice was issued to the opposite party. Opposite party. Opposite party. Relevant would be to opposite party. Despite service, opposite party did not appear before the court. Hence, on 3/9/2024, the IIT Mahila PS Bhubaneswar was directed to serve the copy of the petition on opposite party number 2. Mrs. Sarita Marana, appealing for the state, submits that the IIT Mahila College Bhubaneswar has already served the copy on opposite party number 2. Despite service in 2 different modes, the petitioner opposite party number 2 has not appeared before the court. Therefore, this court is proceeding with the matter in absentia. It is borne out from the record that the parties have settled their dispute, and on the basis of their settlement term, the marriage between the petitioner and opposite party number 2 has been resolved by the family judge Puri, while its judgment dated 19/8/2022 in CP number 183 of 2020. The appraisal of the aforementioned judgment of the family judge Bhubaneswar Puri reveals that the opposite party has not only accepted the permanent alimony of 4 lakhs as has been decided amongst them, but also agreed to cooperate the petitioner for termination of the criminal prosecution initiated by her. In the evidence, this aspect of the matter could be found from the evidence of the parties, which reflect in page para 6, page 34, para 6, page 34. Since the opposite party number 2 has already given consent for dissolution of marriage due to civil marriage, which culminated into when the judgment dated 19/8/2022, passed by family Judge Puri in CP number 183 of 2020, and she has already received the permanent delivery. It is obvious that she is not interested to participate in the proceeding. That perhaps the reason that despite service, she has abstained from participating in the proceedings. Regarding that to the tax article that we have dispute, the dispute is arising out of the matrimonial report. I am inclined to the petition. Once. Leave the matter tomorrow. Since the petitioner is substituted, if the petitioner is not hearing the report, leave the matter day after tomorrow. Yes. Day after tomorrow, let him.
Oblast.
Yes.
61.
Yes.
May I please, Your Lordship. My lord, the petitioner is challenging the order under Annex 4, 4 and 6. Sorry, 5 and 6. My lord, here, the learned subdivisional magistrate, beyond his authority and scope, as envisaged under Section 144, handed over position to the opposite party and acted like a competent civil court.
This is the proceeding under
Section 144, my lord. My lord, kindly see the petition.
Where the position is given, that's it.
My lord, kindly see page 46, 46 and 47.
47.
47. 46. My lord, 47.
I'll issue notice.
Notice was issued and somebody was declared.
Notice was issued.
Yes, sir.
My lord.
Huh? 3 and 4.
My lord, I am reading the relevant portion.
3 and 4. Listen.
Peruse the case record and gone through the relevant
1 minute,
documents
sir.
filed by both sides. The
3, 4. No. Neither editor, no, somebody else.
Awaiting service on 3, 4. Awaiting service on the opposite party number 3 and 4. Leave the matter on show.
62.
Okay.
Yes. Being for questioning of the proceeding filed by the opposite party number 2 on the ground where the divorce has already been allowed. Your Lordship, may I read the following para of the running page 36 of the judgment passed by the
I'll issue notice 498.
notice ଯାଇଛି ଆଜ୍ଞା ନା ସେ ଏଠିକି ଆସୁଛନ୍ତି ନା ତଳ କୋର୍ଟରେ ବି ଆଫେୟାର କିଛି କରୁନାହାନ୍ତି ତେଣୁ ସେଇଥିପାଇଁ ଆମେ
Service through IAS. Service through IAS. Okay. There are 2 and past.
obliged.
Yes.
63.
Despite service opposite party none appears for opposite party number 2 in the interest of justice. The service on opposite party number 2 be affected through the IIC so and so. Which police station give? IIC? Which police station?
IIC Lordship. IIC Mahila Police Station Bhubaneswar. Mahila PS Bhubaneswar.
Okay, Mahila Police. Yes. Yes. 63.
Right. My lord, in this case, I am challenging the cognizance order taken under section 92 of the Factories Act. My lord, your lordship may remember, your lordship has recently delivered a judgment in
Your Lordship is directed to obtain instruction, my lord, because he is admitting that he is aware, but he stated that due to delay filing of this, he has cleared.
106 of the Factories Act, that is the limitation. Your lordship has passed an order very recently, so I am covered by.
Show me the information.
My lord, I
Form
just,
17.
yes, I will just. My lord, this is the instruction.
Let us see. If it is time barred, it is time barred. What?
My lord.
Yes.
My lord, may I take
Incident taken place?
Well, so, incident taken place on first
18-1.
18-1, date of receipt of 24-1-2020. Form 18 is 24-1-2020 and the date on which complaint is filed is 24-6-2020. So my lord, there is a delay of 61 days in the first matter. The second matter, so lordship, in each case I have supplied what is the date of delay.
Yes.
And in the last case only there is a delay of
1 day and 3 days.
My lord, in any case, my lord, once the delay, because that your lordship has there in the order.
Show me the judgment.
Yes, my lord, I am there.
Yes. How many matters you have?
My lord, 4.
4 matters.
All 4 matters are listed today.
Which
Your
paragraph?
lordship, may I take your lordship to page 12 of your lordship's judgment.
Yes.
There is no quarrel on the proposition of law propounded by the
Page 12. Huh?
My lord. There is no quarrel of the proposition of law propounded by learned counsel for the petitioners regarding period of limitation. It is mandated under law that every complaint needs to be filed within 3 months from the date of acquiring the knowledge by the inspector of factories. Accordingly, in the instant case, benefits must be extended to the present petitioner as the complaint by the OP number 2 has been filed after lapse of limitation period. Because admittedly the incident had taken place on 25/6/2017, although it is claimed that on the same day the information was furnished over phone to the authority, but it is factually disputed as to whether information indeed was furnished to the inspector or not. Be that as it may, under rule officially the form 18 was filed on 27/6/2017. Therefore, the limitation shall be reckoned from that day, since the complaint was filed on 4/10/2017, much beyond 90 days. Hence, same is barred under section 106 of Factories Act.
What instruction you have to?
Because the lordship may kindly utilize. This is a case he is claiming that his knowledge is on better.
No, from here only you will get
there
it.
is no
Complaint
knowledge
date, knowledge date.
Because
I will take it from form 18.
Form 18 just
see.
Form 18 just so. It's 23.
No. Give it to him and tomorrow. Verify it. Day after tomorrow. Verify. I'll dismiss it. Give it to him.
May I explain? Not on 13, I am not there from 13 to 15. Any day earlier or after that, I had some person.
17.
Okay.
Give it and you just check it out. I'll verify the date which he has given.
My lord,
the date line is same. The last case is doubtful. 1 day. Calculation may be here and there.
Yes.
1 day.
Your lordship, he may check.
Yes. Check it up and
Oblige.
and forget about when it was informed to. No, listen. See, there are two, three things. When the incident has, takes place, they telephonically inform to the inspector. You ignore that day. Officially under form 18, it has to be intimate. From that day, you recon it. As simple as that.
My lord, I was being aware of your lordship judgment. I have that's why not have done the date of knowledge. I have done date of filing of form 18. So that's why I have not seen what where
that is officially intermittent.
My lord. Again.
Oblige. Yes.
64.
May it please your lordship.
Yes.
That matter, my lords. Lordship, maybe there are 2 criminal miscases. One for the financial 1920, another is 21-22. That is, my lords, 2164. 2164, my lords, of 2024.
Yes.
That relates to the year. My lords,
what are these matters, by the way?
These are my lords, these question, my lords,
TDS
whether first preliminary objection is whether legislature in the CRPC has exempted the union government while filing the complaint under section 190 of the CRPC, that you need not file any, support any affidavit or any verification or any Yes, ma'am.
applies to this kind
Priyanka
of case.
Srivastava, now also another judge.
Other judgments are there.
There,
Yeah,
judgment.
what is that? Kind of-
Does the legislature make a distinction? The answer is no. There is no distinction. Everyone is common before the
Every litigant is same.
yes. That is the question matters. And other things are there, but let your lordship may decide
But
the first question.
Mr. Gedia is.
And further,
You have to just tell us.
In this, regarding this, my senior is going to argue over that particular point regarding this affidavit. For that reason, I need 1 week.
Let it be, sir, next week.
Next
Next
week.
week.
Lordship may
On
fix
request
a
of
date
Mr. Gedia.
at 2
Yes, yes.
p.m.
Put a date, and it's very interesting issue. Let us.
Yes, yes.
Have you got some judgment?
Yes,
You
but-
might be armed with it.
But the fact remains that the legislature doesn't see any difference.
Don't go to legislature. Do you have
Yes.
any
Yes.
judgment?
Correct.
Yes, sir.
Legislative intention, when you speak, when you don't get any judgment.
Our content.
Generally, you might not have found any judgment. So therefore, you have gone to the high peak legislative intention and all.
That's a work in progress always. Will not still the matter gets heard.
Correct.
That means you don't have a straight judgment. If you have a straight judgment, so it.
State judgment as these only.
Otherwise, then 190 will be interpreted, legislative intention and all these things will be.
My lords, it's as simple as that, my lords. There is no distinction.
So therefore, there is no judgment.
No judgment.
That's
Judgment is for the common man.
Had it been a case that somebody is going and lodging an FIR, then that's a different thing. This is not that.
It's a complaint.
This is a complaint. Where the magistrate has to take cognizance on the basis of a prima facie reading of the case. Now, how do you ascertain that without an affidavit? When the person who's coming is not swearing that whatever he's saying is correct, then how do you take cognizance of it? And
Then the officer who is swearing, he has to gain the personal knowledge, then he has to file the complaint.
And he has to say that.
To that extent, at least he has to say.
Whatever he says is
Yes,
on
yes.
the record.
To that extent, at least he has to say on that.
Like
your lordship.
Still you
in
try to find out.
In the writ petition, when we are filing the affidavit, whether Union of India or any petitioner, we are saying that para so and so is based on official knowledge. Para so and so is based on personal knowledge. So therefore, my lords, why this format is required? Because suppose a false thing is stated, then he is committing.
And then the court will found whom?
Yes.
Liable.
Yes.
Suppose 340 is
Yes.
initiated.
Exactly.
Against whom?
Yes.
Your lordship, when we file.
And he say that I had no personal knowledge, I will file it. So then he is escaped from 340.
Your lordship, it's.
That is their argument. I am not saying.
Our clearly mentioned when we file this application, name and address of the complainant, which that duly signed with every documents. Union of India.
No, Priyanka Srivastava says the affidavit has to be there.
Yes.
But in
Merely because you are a Union of India,
it's not required.
can you be, then you satisfy that.
Yes.
Not required.
Your lordship will hear this.
But tomorrow something wrong has gone on the complaint. They want to prosecute you under 340.
Yes, madam. Much obliged, madam. That is the.
Then in that case, he can take a plea that there was no, I have not filed affidavit. Whatever was given, I thrown it on the court and court has done it. So how can you hold me responsible for
Much obliged,
340?
madam. That is the question to be answered by this.
That is indirectly they are saying that.
Yes, madam.
That is the reason 190 says you have to give an affidavit.
Madam.
In the official capacity or otherwise.
Yes.
You meet now, you got a little idea about it. Okay.
So, lordship, keeping it to next week.
Next week.
Much obliged.
20th, huh?
20th.
Come with preparation, don't.
Madam.
Entry order to continue.
Entry mode to continue.
20th there's some difficulty.
19? Can you?
Or the week there.
21st?
20th, 21st, plus there's some difficulty I have having to travel.
Also 19th then. 19th.
19th. Great.
Much obliged.
Come with the written
Yes,
note so that
yes.
it will be easier
Yes.
for me.
Much obliged.
Okay, plus entry order.
Entry mode to continue.
Great.
And I will pass a common order in so far as this is concerned. I will not go into merit
Yes,
and
yes.
thereafter.
Yes, only, yes.
In fact, Milods, apart from that, on merits also we have a very strong case. So that also will.
Merit will see.
When the situation.
Merit will see. First, let us.
Your Lordship,
I don't think they can get over this.
I'll be large on the dispensing case only.
If they can't get over, then I need not go into merit.
Yes.
On that basis, we will cross it.
Great.
66.
Yes.
Disputing the date of birth, the lawsuit is directed for filing of affidavit indicating that the source of this date of birth and he has filed out an annexure 3.
This is the problem. When you pass an interim order, this is the problem. Nobody comes. There is an interim order. Non-APS for the petitioner. In the interest of justice. Adjust evident solution. If next time nobody comes, then we'll see.
67.
May I please, Your Lordship?
Yes.
Petitioner challenge the passing of the criminal proceeding matter
Yes.
on the ground that the my lord, can it on to page 13, my lord. That is the complaint. It was lodged in the year 2002, my lord. 20 August of 2002. The present petitioner resigned from the said company in the year 1996, my lord.
What is this complaint about?
Complaints is under section 23 and 24 of the Contract Labor Regulation and Abolition Act. They have not displayed how many workers working under the company.
Anything survives in this complaint? The complaint was filed long back.
Long back, my lord, that is running, my lord.
What is the status?
Status, my lord, I am page 36, my lord. I am entire order sheet I am filed. Page 36 is the last portion of the order. That is fixing to 23/12/2024 for hearing. Issue someone to CSWS fixing to 23/12/24 for hearing.
Final hearing.
For hearing. Now the complainant has not adduced their evidence.
Are you appearing, sir?
Well,
in the similar situation,
they have. I am opposite party number 2.
What is this stage? 2002. Are you serious about it?
Well, in the similar situation, already this Hon'Ble Court has been quashed the proceedings. In another case.
See, 2002, these are.
2002, since 1996, I have resigned from the directorship. That is under Annex 4 series, my lord. My resignation letter and acceptance letter.
Are you disputing about the Form 32? Where is Form 32 you have filed?
Annex 4 series, my lord, relevant page 40. Page 40. 41, 42 is the receipt. Page 42 is the receipt.
32, Form 32, 1990.
Form 32 in page 40.
96, that is.
That is in 1996, my lord.
Yeah, you have filed there. Form 18/3/1996.
Yes, my lord.
Yes.
Since then, I am resigning from the directorship of the.
Where is the name of the director?
My lord, that is.
Mr.
They have taken
Niranjan Lal.
My lord, I am filing the annual return of in the year 1999. The relevant page is 46. There are 3 directors: Niranjan Lal Todi, Anil Kumar Todi, and Debasis Samantrai.
But this is Niranjan Todi's.
No, my lord, this is Rajkumar Todi. Here the present petitioner is
Rajkumar Todi, father's name. Okay.
Yes.
Rajkumar Todi. And
Todi.
who are you here? Rajkumar Todi.
Yes, my lord. I am Rajkumar Todi.
Rajkumar Todi. And show me the complaint.
Complaint is annexure 1, my lord, page 13.
Yes.
That is in respect of Khajana Project and Industry Private Limited. That is a company. page 13, my lord.
Yes.
My lord, that is complaint under section 23 and 24.
Khajana project.
Labor and against Mrs. Khajana project and
What are the allegations? Let us see. Allegation pertains to
allegation that rule 78 A, I, double I and third I and 75, 78, 76. That is, they have not reflected the minimum wages and
where is that? That's what I want. Where are the facts?
Well, 14, page 14.
Contravention, nothing is written.
Page 14.
Yes, what do you say?
Lord, one thing only that he has applied for that, whether that has been accepted and not deleted or not, that is the
Previous criminal mischief accept that.
No, here it is written that they are not disputing. Now who is disputing?
Well, in one case they are not disputing, in another same documents they are disputing.
Rajkumar told you only.
that he has supplied in this
Then
case.
what else remains? Kind of petitioner petitioner has been prosecuted in what is the case number?
Case number 2 CC 94 of 2002.
94 of 2002. For on the basis of the PR received under section 23 of the 24 bracket C 23 of the 24 CL bracket RA Act against the accused person. Against the accused person. The present petition is pending since 2002. The counsel for the petitioner submits that the petitioner has already resigned from the directorship of the accused company, namely Messrs. Khajana Project and Industries Private Limited. Industry Private Limited. Company name Khajana, and he has relied upon the Form 32, which has been filed by him on 18/3/1996, placed on record as Annexure 4 into the present petition. Relying upon the said document, he submits that the present petitioner has already ceased to be a director from 18/3/1996, and the alleged offence has, if at all, has been committed. The same has been committed after the petitioner resigned from the company. And he has also relied upon a order of this court passed in criminal MC number 3186 up to 2019, passed on 19/4/2023. The petitioner, by relying upon the same Form 32, has approached this court for quashing up the another case initiated against him, being 2 CC case number 28 of 2023. 2020. This court, by relying upon the Form 32, filed by the petitioner, has quashed the proceeding initiated by the initiated against him, and the for ready reference, the order dated 19/4/2023 passed by the coordinate bench of this court in CRMC number 3186 of 2019 has reproduced. So and so appear for the Union of India, and submits that the Form 32 which has been filed, whether the Form 32 has been accepted or not, it will be disputed question of fact. So therefore, he opposes the prayer made by the petitioners. I have perused the documents placed on record, and the order place reliance upon the order dated so and so passed by the coordinate bench. The Form 32 on the basis of which the 263 which has been passed is not disputed. Hence, the Council for the Union of India, who is disputing the Form 32, has no basis of has the opposition of the Union of India questioning the Form 32 has no leg to stand. No leg. Hence, the petition deserves merit accordingly. So the petition is quashed. Yes. Proceeding is quashed. Huh? Yes.
Proceeding for the only this
Quasi petition. Obviously, quasi petition.
entire proceeding is not.
Quasi petition. Yes.
My name is
Yes.
Manoj Kumar Pati, Senior Pendant
Manoj
Counsel.
Commission.
69.
Wait, please, Your Lordship. Item number 69, my lord.
Yes.
My lord, the FIR registered on 2010, my lord, and the charge sheet submitted 2011. But my lord, even after lapse of 15 years, my lord, the trial has not yet been concluded, my lord. Previously, Your Lordship issued notice and called for a status report from the learned court below.
We got issued from JMC.
Status report.
Yes.
After the report called from by this honorable court, Your Lordship, they examined 2 witnesses, and they both are hostile, Your Lordship. They are saying we don't know about the case.
What is this? This he says that the informant in this case, who was the then BDO of so and so block and other CSWS, are not attending the court to produce evidence.
Last 15
has to be issued. They are there. Your officer. If they are not attending, why should he suffer?
Target this.
Why should I direct? It is his. Then you drop it. If you can't produce your own witnesses, why should the accused will suffer? Your own officer, BDO and CHW, private persons were examined. And this matter is going on since just 2 decades.
I'll go through the report.
Go through the report and address this. I will quash on this ground. If you can't secure presence of your own officer as a witness, why the accused will suffer?
Yes.
Isn't it? You read it and just address it. Okay. The pursuant to the order dated 2/12/2024, the learned JMFC Nimapura has submitted a report dated 28/2025. The report reads as under. It is surprising that the official witnesses are not turning up to depose before the court, which is the cause of delay in disposal of the trial. Disposal of trial. State Council submits that he would seek instruction as to why the official witnesses are not appearing, not attending the court to adduce their evidence. Leaves the matter after 1 week or 2 weeks. You give complete this thing. Yes. And they must be taking pension if they are retired. If they don't go, why they are not entitled? You take action. Yes.
70.
Service. appears. None appears for the party in the interest of yes. Third gender. Appeal.
Arjun.
71.
Arjun.
Appeal. None appears for both the parties.
May I please, my lord? The notice was issued to opposite party 203, my lord. That was made sufficient, my lord.
Sufficient. The notice on opposite party number 2 and 3 is sufficient. However, none had entered appearance. In the interest of justice, one more opportunity is granted to them. Please the matter on such. Yes.
72.
That's here. What has happened is a 1cc case of which cognizance was taken under sections 468, 420, 506, and 294. That was dismissed due to default, my lords. What had happened was the complainant petitioner, while he was going to the court, he met with an accident, and for that reason, he could not appear. Through his advocate, he filed a time petition. That was rejected, and the entire case was dismissed on the ground that the petitioner does not have interest to proceed with the matter. So what I pray, my lords, is that your lordship may watch this and my lords may relegate the matter to the learned court below so that it can be heard on merit and decided, my lords.
My lord, I am the accused.
Yes.
My lord, I am for the accused opposite party. The complainant is a local resident. After 8 adjournments, he did not come and filed a petition. I have fallen from his scrutiny.
Show me 8 adjournment.
Let it be remanded, but expeditiously the case.
That's what he says.
Yes.
The matter was taken
Expeditiously it should be disposed.
for hearing on 13/12/2024 and the following order was passed. Persons to the notice shown to enter appearance for opposite party, number 2. And opposite party. He submits that the petitioner had sought repeated adjournment before the court below. Therefore, the trial court has rightly dismissed the complaint for non-prosecution. At the same time, he says that even if it is remanded back to the trial court, a time-bound direction may be given for disposal of the same. In view of since there is no serious opposition to the petition, I am inclined to allow the same and pass the order dated 23/9/2024 and restore the complaint to its original file. Direct the SDGM Commissioner to dispose of the appeal as expeditiously, dispose of the complaint as expeditiously as possible. Yes. Next. Next.
73.
With 73 minutes, I'm appearing for the petitioner on VC minutes.
Yes.
The notices was issued minutes to the opposite party.
I'm appearing minutes on behalf of the opposite party.
Yes.
The
Yes.
present case is a case and counter case minutes where 2 FIRs have been lodged. And we have also filed a CLMC bearing number 389 of 2025. What I pray, fresh CLMC has been filed. What I pray,
You are asking for quashing?
I pray, both the CLMCs be heard together and disposed of together.
Yes, Mr.
Malice, I do not have any objection to that. Malice, one submission subject to your lordship's acceptance. Malice, since they have filed a quashing and we have also filed a quashing, it arising out of a civil dispute. In the meantime, if the parties can resolve the issue through mediation, and they may be protected.
What do you say?
I have no objection, Milord. I have no objection, Milord. But in my CRLMC, no notice has been issued, Milord.
Now he will accept notice and
Milord,
I'll take
that is if that is done, I have no issues, Milord.
Mr. Ansuman Rai entered appearance on behalf of opposite party number 2. He submits that his client, one client or how many clients?
1 Milord.
His client is an accused in the cross case initiated by the petitioner. For quashing of the case initiated against him, he has filed CRLMC number
389 of 2025.
389 of 2025. He praised that both the CRLMC may be heard analogously. Mr. Maharana, the counsel for the petitioner, submits that in fact there are cross cases registered against each other by the petitioner and opposite party number 2. The dispute is arising out of a civil dispute is primarily civil in nature. Hence, he submits that the matter could be explored for the purpose of a out-of-court settlement. Regarding being head to the submission made by the parties at the bar, I'm inclined to refer the matter to Mediation Center, High Court Mediation Center, High Court Mediation Center for exploring a possibility of a settlement. Coordinator of the Mediation Center is directed to fix a date and intimate the parties to participate in the mediation process. Awaiting the mediation report, lease the matter so both the matter, lease both the matter and in the other matter also will go for mediation. Okay.
In the present CRLMC, there is an IA which was to be considered upon appearance. Since the parties are in the
what is the stage? What is the stage?
Cognizance. My instruction is cognizance is taken, and thereafter
the parties are now relegated to explore the possibility of a out-of-court settlement. They are given liberty to move application before the respective court for an adjournment, awaiting the mediation report. Okay. In your case also same order. I have yes.
Same order.
74.
Grateful.
May I please, your lordship? Lordship, I am for the OP number 2, my lord. Item number 74, my lord.
Yes.
I have filed counter affidavit, lordship.
Okay, this is he is an MLA, ex-MLA. He is an ex-MLA.
XML, yes.
Then it has to be consent court, right? Or this petitioner, he is an ex-legislator. He is seeking questioning of the proceeding initiated against him, being case number 29 of 2024. Lease the matter before the assigned bench, subject to everyone approves.
Lordship, any particular date, my lord?
Yes. Next.
76.
Lord, here the accused is before your lordship. The 138 proceeding was initiated against him. My lord, there I filed an application to send the check to the handwriting expert, that is Annexure 3, my lord.
Yes. Yes.
My lord, the learned court below, your lordship may kindly turn to page 39.
Yes.
Order dated 7/8/2024. Perused the order sheet and found that no such petition is filed. From the order sheet and found that no such petition is filed. My lord, may kindly turn to page 43. This is the petition which I brought out from the court record, that such petition was there available in the court record.
Pending.
It's pending. Secondly,
This might have escaped notice. Therefore,
yes.
I'll direct
another point. Now, your lordship may kindly have a glance to Annexure 4, page 45. There I filed an application because after that order, the trial court precluded me from proceeding with the case because I cannot.
Thereafter, you move this application.
The application to send it to the handwriting expert was moved after the closure of the case by the complainant from the side of the evidence side. There I filed an application. He rejected my application saying that no such petition is available, which is an error of the record on the face of it. Thereafter, my lord, I filed an application under 311 to permit me to cross-examine the prosecution witness number 1, because, my lord,
cross-examine PW1, complainant.
Complainant. My lord, here the question
has been rejected.
which has also been rejected
Show
on.
that order.
Yes, that is under annexure 5 at page 47.
Yes, what do you say?
My lord,
He moved an application. See,
yes,
he
my
moved
lord.
an application for sending the check to a handwriting expert.
My lord.
That application was there on record.
Yes, my lord.
And the trial court says there is no application, rejected.
My lord.
Thereafter, he moves an application under 311. If you have, despite the fact that application was there, you said no, there was no application.
My lord.
Please allow me to cross-examine.
Yes, my lord.
Yes.
But what happened in this case, my lord? When the complainant was examined, he has admitted that the signature is of his. My lord, this is the copy of the evidence.
What are the
The question was posed.
Yeah.
Exhibit 1, question number 6, exhibit 1 is the check bearing number so-and-so dated so-and-so for an amount of rupees 10 lakh drawn by you in favor of PW1.
What are the proposed question then? You have admitted.
Signature ta moro, account ta bhi moro.
Then what are the proposed questions? Even if I allow you to call.
Yes, in fact, my lord, that mistake, the learned trial, he has not given the proposed question.
Then if you are asking for a witness to come in a 130,
yes,
you have admitted everything.
Yes,
what will you do?
311 petition, I have to give the proposed question that I want to ask. That is absolutely settled position, my lord, nothing. But in this application, there is no such.
Then why should you call them?
My lord, question is now for sending the document to the check to the handwriting expert, which my learned friend is.
No, but you have not challenged that order.
No.
Where it says that there is no application. You should have challenged that order.
Yes,
in the order sheet also, it has not been mentioned anywhere that such a petition is pending.
No. That your lordship may kindly see.
Yes, madam.
That is there in page 48.
See, the page 43, the application
Madam.
was pending.
Yes, madam.
Whereas the trial court in 39, page 39, says there is no such application is there. Page 39, if you see.
Yes, madam.
No such application is there. Where is that? Page 39, last.
My lord, the petition was filed on 8/8/2023, my lord.
Yes, peruse the order sheet and found that no such petition is filed. That is on 7/8/2024. Let us see for page 43. Page 43.
It was filed on 8/8/23.
8/8/2023.
Yes, my lord. 8/8/2023. There is no mention about the filing.
No,
of such
see, come to page 43 at the side. Copy received with objection. 8/8/2023. Side handwriting. That is in the left.
Yes, my lord. 8/8/23.
So
yes,
then 8/8/23 it was filed.
My lord.
And
yes, my lord.
now come to page 39. How the court says that it was not there?
My lord, my lord, I pray for.
No. See, no. There is a point.
Yes, my lord.
On 7/8/2024 it is filed.
No, my lord, it was
See,
filed.
the proceeding is 7/8/2024.
Yes, but it was
filed next day.
My lord,
That day it was not pending.
No. Order dated is 7/8/24.
When it was filed?
It was filed in 8/8/23.
Oh, 23. Okay.
My lord, page 37, my lord.
My lord, at least I will not do that mistake before this.
No, I got to.
Yes, my lord, page 37, my lord.
Legal side. At least I will be very cautious.
36 what?
Page number 37, my lord. Order dated 8/8/2023. 8/8/2023.
Yes.
Both the side are present and file has a put upon 1/9/2023.
That's right. See,
Yes, my lord.
unfortunately, in the proceeding, it escaped notice of the court. But doesn't mean that it is not filed. It is there. You have received it.
Yes, my lord.
And if an application is there, it has to be attended by the court. Reject it, no problem.
My lord, once, though I have received the copy, but it has not been put to the file of the court.
I don't know.
Record,
I don't
my
know.
lord.
It may be there or may not be there.
Since there is no certified copy of the such or such.
So there are now two positions.
Yes, my lord.
The application remain undecided.
Yes, my lord.
What will be the fate of that application? The court has to decide this way or that way, reject or whatever. Second is, since that application has not got audience, he moved a 311 application.
My lord.
Unfortunately, in 311 application, he has not put any proposed question. Now you have pointed out these two things.
Yes, ma'am.
After these two things which has come on record, and I don't think 311 will serve any purpose.
And one thing, my lord, I'm not casting any aspersions on the court, but your lordship may kindly have a glance to page 48 more and more.
48. Yes.
In the present petition, it is claimed by the defense that such a petition was filed on 8/8/2023. On 48. On perusal of the order sheet dated 8/8/23, filing of no such petition is reflected. On further perusal of documents on the case record, it is found that an application is on the case record wherein prayer for sending it. But can the court do this type to the accused?
But it was
Yes,
there.
I am an accused, my lord.
It was there.
It to be heard by the court, madam.
It was there.
But that order, as rightly your lordship said, in my prayer, I have not questioned that order.
Then what to do now?
I have questioned only 311 order. But this is the fact which is there, madam.
Once you admit, even if I allow this application to send it to handwriting expert, what will you get?
But your lordship,
It is only to linger the matter, my lord.
Kindly see page 9 for a moment.
9.
Yes.
Okay. Yes.
And after hearing both the parties, the impugned order dated such and such passed in 1cc number such and such, rejecting the petition dated 28/8/24 filed under 311 to recall the order dated 3/8/24. But it is a combined order. So if he recalls the order dated 3/8/24 and thereafter considers 311, then purpose is served. Because now two anomalies are there. 3/8/24 order is staring at me. Because of 3/8/24, he did not allow 311. But in 311, rejecting 311 order, he notes that though I have rejected it, but from the
You are correct, but what will be the end result? If I allow both the application. For example, I allow both the application, 311 also, and you are, I'll send the check to the, but in the face of the evidence which you have given,
that cannot go.
That is staring at me.
Then
question is, if your lordship may see that portion of the evidence, your lordship mechanism, jyoti utke dekhan sir.
Why have you answered like that? Yes.
Page 2, my lord, question number 6.
Your lordship may read it as a whole. In fact, the accused statement is my first defense. He states
signature more, account be more. Account be more, he pare.
He is doubting, casting doubt on his own account.
After this, what will you do?
Whatever is there, my lord, I cannot hide it because my land brother has produced it.
I don't think because of this you have a problem. Otherwise, technically, one application has to be heard. But even if it is heard for what? Yeah, after this, after you have admitted it.
I leave it to your lordships.
Right. Mr. Bose, counsel for the petitioner. No, the petitioner is exploring the following relief in the present petition. Mr. Amit Bose, land counsel for the petitioner, taking me to the proceeding for the court below, dated 39 dated.
My lord, that is 7/8/24 at page 39.
Submits that an application submits that the court below has completely erroneously recorded that there is no application pending before the court moved by the present petition seeking referring the subject check to the handwriting experts. Handwriting experts. However, by pointing out to the annexure 3 to this petition, he submits that on 8/8/2023, the application was moved and the copy of the same has been received by the opposite party by endorsing that copy received with objection. The fact remains that the application for sending the subject check to the handwriting expert was pending as on 7 as on what is that? 13, as on 7/8/2024. Subsequent thereto, the petitioner moved an application under section 311 CRPC seeking recall of the complaint, for further cross-examination. The said application was also turned down by the court by the impugn order dated.
Well, that is order dated
3/8/2024.
No. 311 was rejected on 26/11/24.
26/11/2024. Page.
Well, page is 47, annexure 5.
Inter alia, recording. Inter alia recording agenda. Page 48, last paragraph in the present petition. In the present petition, last. Mr. Bose, legal counsel for the petitioner, submits that under the submit that the on the basis of the presumption that the no application was moved by the petitioner for sending the check to the writing expert. The petitioner has the trial court has proceeded and passed the impugn order. Therefore, he submits that neither the application moved by him for sending the check to the handwriting expert got was heard, nor the application under section 311 was properly appreciated in the aforementioned background. Hence, according to him, both the order dated
7/8/24 and
7/8/2024
and 26/11/24.
26/11/2024 has initiated, and his valuable and indefensible right to leave defense evidence has been taken away. Legal counsel for the opposite party by taking me to the taking me to the cross-examination of the Suresh Kumar Senapati's
The present petitioner.
cross-examination of the accused, no?
Yes, sir.
Accused submits
That is a defense
accused.
statement. That's not cross-examination.
Sorry, taking me to the statement of the accused recorded under section 313 CRPC submits that the petitioner himself, while answering to the question number 6, has inter alia stated as under. Question 6 has under. On the face of the aforementioned admission by the accused in his statement under section 313 CRPC, even if the impugn order is set aside and the application moved by the petitioner is allowed, the same would be of no consequence. Hence, he submits that the petition deserves no merit. I have given careful consideration to the submission made by both the parties at the part, and of the opinion that in view of the clear admission on the part of the petitioner in his statement under section 313 CRPC, even if the application moved by the petitioner for sending the check to handwriting expert or recalling the complainant for further examination will have no consequence. And moreover, in the 311 application, the petitioner has not given any proposed questions which may be relevant for the purpose of putting it to the complainant. In that view of the matter, there is no merit in the present petition, hence the same is dismissed. Yes.
Well, and on this 313, I was arguing a criminal record. Only on this statement, this non-reply in a proper way, I lost the criminal.
Many a time what happens if you don't have a defense counsel, there is a chance of acquittal. If there is a defense counsel, then
Chance of conviction
is there.
more. My lord, I lost that
Time-
appeal. I was arguing before my lord Justice Sahu and Honorable Justice C.R. Das. Only on this statement I lost.
That's the whole difficulty.
I had taken a
Very specific question put and admitted. He should have said that I don't know. Then
Then the onus will have shift on it. But once
Signature is not mine.
once I
something of that
Sorry.
sort, evasive answer, then also you would have a case to argue, you know. Once you admit, then it's gone, everything gone. Yes.
grateful.
Published, man.
Yes.
77.
My lord, on behalf of Mr. Dole, Mr. on the legs, let it come from my lord.
On the case.
70 also same.
70.
79.
Definitely, the court case, Mr. Das is Hon'Ble also that vigilance case, one issue, 4 FIR, one already quashed. And another 3 cases only hiding out of same issue. I have given the judgment also. I mean,
Say other, the other accused, it is quashed.
yes.
Okay.
But in respect of the petition also, in one case, he had made.
Quashed.
Was.
So let it be there, then
He
I.
was a party court judgments to that effect.
Where is that judgment? Can you?
I have given the annexure 7 will also.
Annexure 7.
That is Prabhakar Naik.
Devendra Kumar Panda.
Devendra Kumar Panda also quashed, my lord. A same issue, my lord. Only here, last occasion, he has taken to instruction for lordship.
What was that? What is the case?
Yes, it is that whole issue, my lord. The present petition is appointed by the OCCA to collect the coal from the MCL to distribute to the other agencies.
Okay.
That is the decision taken by the others, my lord, the district industry center, my lord, DIC. Present petition has absolutely no role. To that extent, he has already been appointed in one affair. That is annexure 7, Devendra Kumar. Same issue, same affair. Because of the 4 divisions, 4 affair has been lost. Otherwise, the issue is the same.
So then I'll keep it on the
Yes.
board. Keep it in the board. Huh? Huh?
Weekly.
Weekly stop record. Keep it in the board that we'll finish it up.
Right.
3 matters can be
3 matters,
disposed of.
yes.
3 matters can. Same Devendra Panda.
Same.
How many cases you have?
Only 4 cases, my lord.
Only.
He already quashed. Another 2.
You were what? You were.
Devendra Panda.
No.
Appointed by the OCCF to collect the coal from the MCL to distribute the agencies.
Same allegations.
Yes.
In all these.
Yes, all this.
Miscellaneous is देखो ये रहेगा next week और को कहीं weekly वाले पढ़े
It will be only it's a common case.
Supplement. Let it be there in supplement.
Right.
Please. I'll just go to what. 80. Any matter could be disposed of within 5-10 minutes.
Item 90. Item 9.
Any matter could be disposed of within 5-10 minutes. Then tell me. Otherwise, he will adjust the thing.
My lord, item number 80 and
We'll deal with that.